I have an extreme urgent matter. My residential house will be demolished on Saturday. I am paying leave to move it on Friday. But unless there is a recording that the matter to appear on Friday, I cannot file it and serve.
What is your urgency?
Urgency demolition order has been passed during pendency of my conversion application. On Saturday, it will be demolished. That's the extreme urgency. My residential house. Only noting the matter to appear on Friday or Thursday at the top. Otherwise, my lord, I cannot file it and serve the copy to the other respondent.
Leave granted.
Milord, may I seek my lord's kindness? Your lordship was kind enough to allow the mentioning made by my junior. But instead of hearing, Milord, it should have been upgraded as an application. Your lordship was kind enough. It was our mistake, not the mistake of the court, Milord.
Oh,
So,
it's
Milord,
an application.
application. Milord, this hearing was upgraded.
Heading আসবে।
My lord,
Heading আসবে।
Keep you obliged.
my lord, I pray for upgradation of 2 e-rickshaw matters, my lord. The factories and the showrooms are closed, my lord. Identical matter is covered by your lordship's judgment, my lord.
Upon notice.
My lord.
Your lordship's kind indulgence to mention one matter, my lord, as per lordship's previous direction, the matter was to appear today. My lord, the matter is not appearing, my lord. In fact, my lord, the interim order is expiring on 31st. So with notice, my lord, I mentioned so that it can be come under heading extension of interim order. I have served notice. Order copies are all there, my lord.
Extension of interim order.
But may I permit to mention?
Yes.
May I permit to mention a matter? This matter is regarding a local car. Two union and state are both fighting for my land. Mr. Loknath Mukherjee, senior advocate, had addressed the matter, my lord. It was hard one day. Matter was supposed to appear on 19th April.
It's a hearing matter.
No, my lord, it's on motion because no affidavits, only reports. My lord had directed the matter to appear on 19th, but my lord had it is appearing as item number 63. I have given notice, and anyway,
63.
63.
63 is it's appearing fairly at the top.
And my lord, the interim order is
Mention when is it expiring?
31st.
So file an application for extension.
No, 31st it is expired. May. So I'll wait for some time, my lord. Let me wait till Monday, then I'll mention.
Yesterday I mentioned this matter, my lord. When my lord asked me to give notice to the other
Sir?
side, yes, I.
Yes.
My lord, may we permit to mention one matter, my lord. I have filed this matter, my lord. The urgency is that, my lord, the Jilla Parishad, my lord, has, my lord, going to construct a land, construct a road, my lord, on my land, my lord, without giving any actual notice or, my lord, nothing, my
No,
lord.
it's not
I've
a
already-
sir. Please wait for
My
something.
lord, it will be infructuous,
Wait
my lord.
for something. It will not become infructuous. You are aware. It will not become infructuous.
Praying for upgradation of item number 692 upon notice. Appellate authority has given last chance to obtain a stay from the High Court. The matter was remanded back to the competent authority. They are not hearing. They will pass an order, my lord. We have challenged the order of remand, my lord.
I need to mention item number 775.
Please mention only urgent matters.
Yes, well, I'm praying for extension of interim order.
Extension of
Interim order is upon notice. I'm giving the notice as well as the interim order. I have also an extension of interim order.
Upon notice?
Yes, madam.
Extension of interim order regular. Huh?
My lord, may I be permitted to mention a matter pursuant to my lord's order? I have approached the appellate authority under Rule 51. My lord, the appellate is pending since July 2023. My lord, in the meantime, the local hooligans are extracting sand from my private land. That is why
Upon notice?
my lord, my lord, five same matter.
All appeal pending.
All appeal pending.
You're asking for expeditious disposal of the
My
appeal.
lord, my lord.
Give the numbers.
Faithful, my lord.
With my lord's kind leave, may I be permitted to mention this matter upon notice, my lord. This matter is appearing as 574 in today's list, my lord. My lord, the urgency is that on PW land, an illegal construction has been made, which is creating an impediment in getting ingress and egress.
Answer. You have to. I'm not
May I-
allowing these matters.
May I be permitted?
The matter was directed to appear on 24th, my lord, but it has not appeared. I have mentioned. Yes, my lord. In presence of both parties, the matter was directed to appear on
But what is
24th.
your urgency?
Now, my lord, urgency is with an earlier writ petition, my lord, by state. In that, my lord, they suffered and eviction was allowed. After that, they filed another writ petition. That writ petition, your lordship directed to file a report and granted an interim order, making it clear that it would be heard and disposed of on the next date.
Order.
Lord, it was supposed to appear on 24th April because your lordship directed on 27 March. That in presence of both
It is
sides.
not in the list at all.
No, no.
It
But there was direction that it will appear on 24th.
List include code.
আগের অর্ডারটা খালি দেখে নিন।
May I be permitted to mention one urgent matter, Lordship? It is listed. Lordship, the petitioners are the owner of a property which is acquired by the PWD for constructing a new bus stand, Lordship. But no acquisition is taken place, Lordship. They are forcibly acquired the land, started
Second
demolishing.
in the list.
Yes, your Lordship.
Please wait for your turn.
Lordship, 915, Lordship. There are urgency, Lordship.
Please
If
wait
stay
for your
order is
turn.
not given, Lordship, they will encroach my entire shop, Lordship. There is a shop.
Compensation in due time, sir.
But
Please
Lordship,
wait for
if
your turn.
Lordship is not been hard, Lordship.
You heard what I've said, no?
Yes, your Lordship.
Please wait for your turn.
Lordship.
Yesterday I mentioned, Lordship needs to direct serve the copy. I have served the
You
copy.
served? Yes, give the number.
Your Lordship, may I be permitted to mention?
Lordship, may I have
Your
permission
Lordship,
for mention?
may I be permitted to mention item number 598, Your Lordship, there is a, despite there is a order of removal of illegal encroachment, but respondent authority did not
Wait for
take
your
any
turn.
steps.
Take it up. Wait for your turn. It will be
Lordship,
taken.
may I be permitted?
Lordship, may I have permitted for mentioning upgradation for the structure which is now in existence over the subject plot where the petitioner is lying in a very different position. Anytime this is accident.
So what can the court do about it? Petitioner's building lying in a very dilapidated condition, how will the court help you? The court will not direct repair of the petitioner's building?
Challenging.
Yes?
We challenging against the land acquisition.
Wait for your turn, madam. It will be taken.
Your Lordship, may I be permitted to mention one matter, Your Lordship?
Yes,
Well, I think it is mentioned at the top of the list, but it has not been recorded in the top.
Friday date the note.
Your Lordship, may I be permitted to mention? One upgradation matter, Your Lordship. Your Lordship, the petitioner's land has been acquired by the respondent authorities, Your Lordship. It was heard and directed to keep 3 weeks after puja vacation, Your Lordship. What-
Directed to?
Be in the list on the same heading after 3 weeks of the puja vacation. Your Lordship, it has not come. No, it has been come in the monthly list, Your Lordship, but it is not taken up for
Appearing
hearing.
in the list,
Yeah.
please wait for, monthly list was called entirely, you were not there at that time. So please, monthly list was called, entire monthly list was called.
My
So
lord.
please wait for your turn.
May I permitted to mention, my lord, for upgradation, item number 773 of the today's list, my lord. The petitioner is suffering from cancer, my lord. And it is a LIG plot of land, and the front portion of the land is trying to acquire by the KMD authority. It is
Are you
urgent.
mentioning upon notice?
Hmm?
Are you mentioning upon notice to the other side?
No, no,
You
ma'am.
have to serve notice and come.
I have prescription also, my lord.
Please mention upon
Oh,
notice.
hi.
I'll take it. Yes, I'll consider.
May I have your lordship's kind leave to mention an application in connection with a Group 1 writ petition, your lordship.
What's the application about?
Your lordship, the application is seeking for modification of an order. What had happened was, your lordship, the matter was disposed of, and the state respondents were supposed to put a certain amount of money in the account of one of the petitioners. Now, subsequently, the petitioner passed away, your lordship. So, and it's an application,
Go to the legal heirs.
it has to go to, and particularly, it also, and there's an application for appropriate orders, since one of the legal heirs has been named to whose account the money will go in, your lordship.
Upon notice,
Upon notice, your lordship.
Lordship,
give the number.
Lordship, may I be permitted to mention a matter for inclusion upon notice? Lordship, this is a matter in which I had applied for conversion of a land situated at Malda from Pukur to Bastu. It was allowed. Subsequently, public interest litigation in respect of the said land was filed initially, which was disposed of, directing the district magistrate to consider the matter. With regard to that direction, the district magistrate again passed an order to reconvert the land from Danga to Pukur. But Lordship, my contention was that I had challenged the said order of the district magistrate in the instant writ petition. Subsequently, one more public interest litigation was filed for execution of the said order of the
So this
district.
is under the West Bengal Land Reforms Act.
Yes, Lordship.
This court doesn't have jurisdiction at all. You have to approach the appropriate forum. Conversion is under 4C.
No, Lordship, that order has it was granted. Subsequently, it was again pursuant to
I
the
have followed what you have said, sir. But then since it's conversion and reconversion under the Land Reforms Act, this court will not have jurisdiction to deal with the matter at all. Please consider this and come back.
Lordship.
You have to approach the appropriate forum.
Lordship.
Matters under Land Reforms Act will not be taken up by this court. Okay? Yes, call the days list, please. Jalpaiguri Circuit Bench.
Malad.
Jalpaiguri Circuit Bench.
Malad,
Yes.
I'm appearing, my lord. Pursuant to your lordship direction, my lord.
Your circuit is going on there.
Yes, going on, my lord, because if your lordship direction or affidavit in compliance in content proceeding, my officers, they're
Online?
my lord, I'll just appear before the circuit bench through online and I'll leaving today itself.
Yes.
May I, my lord,
Applicant
the affidavit in compliance, my lord.
complied?
My lord, what happened, my lord?
Yes.
Let a copy of that compliance be also
Yes,
served.
you
my
have served a
My lord,
copy.
my lord.
Just now I am receiving it.
Just to go through the copy and come back.
My lord, just
My lord,
may I
my
indicate?
instructions are nothing has been done.
Yes, may I indicate? Yes, my lord.
Yes.
Because it is, my lord, your lordship directions at page 21, my lord, in my compliance, my lord.
What was the direction?
My lord, direction was that at page 22, my lord, should kindly see the last paragraph of the said page. In view of the above, the writ petition is disposed of directing the sixth respondent, the assistant engineer, pass a final order in terms of the direction of the honorable division bench as stated above within 1 month. My lord, from the date of communication of this order. My lord, this order was for the demolition of the encroacher on the PWD land, my lord. My lord, kindly see what is the order of the honorable division bench, my lord.
21st March order of the division bench?
Yes.
Yes. And where is your compliance? Where is the order?
My lord, division bench order was on 14th June 2023, which is appearing in my compliance report in page 16, my lord. I have annexed everything, my lord. Page 16, the division bench order, my lord.
Yes.
My lord, straight away kindly come to paragraph 8, page 19, my lord.
Yes.
My lord, in this second paragraph, my lord, lordship got it. In this application, there is no material change in circumstances for which we may revisit the same issue. In any event, it has already been observed that the competent authority under the control of National Highways Land and Traffic Act 2002 would consider the objection of the applicant and other agreed parties and decide the said matter in accordance with law, my lord. If any decision is adverse to the appellant applicant is not remedialess, my lord. Then, my lord, next paragraph, then this application stands dismissed. Then, my lord, it is submitted on behalf of the state that the final order has not yet been passed, my lord, and the demolition proceeding has not yet commenced. In the event any final demolition order is passed, the same shall be communicated to the appellant within 48 hours and shall not be implemented for a period of 7 days from the date of communication of this order, my lord.
All this is over.
All this is over, my lord.
Now, where
Then,
is
my lord,
final
your pursuant to your lordship's direction, my lord, that 24th August 2023, your lordship was on 21st August, my lord. Kindly page 24, my lord, in my the
Yes.
compliance. Then the joint inspection was carried out, my lord. It was found they have encroached, my lord. This is the report at page 24, my lord. Then, my lord, page 27. Kindly see, my lord, page 27.
Yes.
Then, lordship, the notice was issued to the my lord 31st August 2023, my lord. All the my lord, the 4 encroaches. Then, my lord, kindly come to page 31.
Yes.
My lord, in the said notice of page appearing at page 27, the date was fixed on 5th September 2023 for any objection, whatever, my lord. So, page 31, my lord, kindly see, lordship got it, page 31.
Direction for removal.
Yes, my lord. So, within requested to remove such within 7 days from the date of which removal, my lord.
Yes.
So, kindly, my lord, that is a 10-10-23, my lord. Then there was an order of the division bench to pass a final order. Your lordship also, there is a direction to pass a final order, my lord. This stands a final order. Then, my lord, in furtherance to that also, because that was the only portion, my lord, to be carried out to pass a final order. My lord, in furtherance to that, what we have done, then, my lord, in the meantime, there was a, my lord, Tista, their flood and the rescue operation was there. My officers were busy. Then in December, my lord, kindly come page at 42, my lord. 39, lordship, kindly come 39.
Yes.
My lord, we have written a letter to the district magistrate, my officer. My lord, my lord, kindly come to the next page 41. last part. In this regard, it is also requested to kindly give necessary deduction to the concerned authority to depute executive magistrate and police force, my lord. So I have sought for, my lord. That is on 22/12/2023, my lord. Then, my lord, on the next day, on the basis of the DM's request, I have specified the date, my lord, for such demolition to be undertaken. That I have specified by a letter dated
3rd
20.
January. Then
Milord, now what happened? The situation on 27th. Sorry, Milord. Then, Milord, on then also 27th of December, we have communicated to the encroachers that such demolition will take place on 3rd January, Milord. That is the letter, Milord, from page 44.
yes.
Lordship got it. Milord, on 28th December, Milord, my officer received a WhatsApp communication forwarding a PDF copy of the writ petition filed by one of the encroachers, Milord, on 28th December. Milord, kindly come at page 53.
Yes.
Lordship, kindly see, this is the order of the 18/10/2023.
There was no stay.
There is no stay, Milord. I'm coming. There is no stay, Milord. And this is the affidavit to be filed, Milord. Then, Milord, on 29/12/2023, the entire matter, Milord, on the last day, more or less, of the year, was placed before me for seeking an opinion, Milord. Then, Milord, now, Milord, I have opined that an opinion, Milord, kindly see that at page 55. No, Milord, not page 55, page 58, Milord. Page 58. Kindly come to the page 59. Page 59, top, Milord. Under the above circumstances, Milord, the undersigned met with the learned additional advocate general Circuit Bench, Jalpaiguri, Calcutta High Court on 29 December 23 and sought legal opinion from him over the matter filed such and such dated 29/12, Milord. On the next day, Milord. Now, the learned additional advocate general such and such has provided his legal opinion wherein has expressed that the demolition program to be conducted on 3rd January 2024 should be aborted till the next date of hearing of the WPA 2509 of
Under what authority?
Milord, I am coming. Milord, kindly come to the division bench order. Page 24. Page no, Milord.
Said 7 days.
No, Milord. Page 19. Milord, kindly come for your lordship's kind consideration.
Yes.
Milord, this second paragraph in this application it is started. Milord, kindly come to the last line. If any decision is adverse to the appellant applicant, the appellant applicant is not remediless, Milord.
So,
Milord, they have, Milord, kindly see. My officer has no problem. Milord, kindly see the moment I have received, because it has not been even communicated.
yes, there is a stay order.
Milord,
You are bound to comply with the order.
Milord, in the meantime, Milord, then the writ petition which has been filed, one of the encroachers, Milord, then it would be infractious, Milord, in that event. Now, Milord, I have
bothered about
Milord, I have bothered because I have bothered about this line only.
You should be bothered only about the order of the
Milord,
court.
division bench said that there should not be there. Milord, they said that
lying.
Milord, the remediless means they filed a writ application, Milord. Milord, I have within 3 days, Milord, I have demolition, no problem. Milord,
say that as soon as the petitioner, as the encroachers file a writ petition, you
no,
stop.
Milord, no,
Stop.
no, Milord, that
Milord,
never
may I
said.
make one thing very
Just a
clear?
second.
You don't need to, sir.
Just a second. Milord, that is not there.
Then,
But Milord, the spirit of the order, Milord,
court's order.
Milord, not Milord. But it was not never, Milord. Kindly.
Let you issue rule. Let your officer.
Milord, kindly see, Milord. The officer, Milord, they have all endeavors made.
No endeavor.
Seeking, Milord, kindly, I have demonstrated, Milord.
This is all eyewash.
Milord, no, Milord. No, with my respectful submission, Milord. No, I was, Milord. This,
wait till the writ petition.
no, Milord. The police help was sought for from the district magistrate office.
Chosen not to give a stay.
Milord.
The writ court has chosen not to give a stay.
Writ court, Milord, only our affidavit direction was given. There was no, Milord, even the yesterday, today, it is running in the list, Milord. Milord, kindly see. Then they would have said, I have filed the writ petition, you have not, I became a remedialist. This is the reason my officer thought it to give a Milord, your lordship.
He does everything except the correct thing.
Milord,
Extend
within tomorrow, for 2 days, Milord, I will demolish, I have no problem.
I'll record your submission.
Yes, Milord, record your
After 2 days.
My lord,
Yes, my lord.
my
No.
lord, I'm just making one
Today is,
submission.
to his,
My lord, my learned senior friend is relying on a division bench's order. The appeal was preferred by the private respondent, one of the persons whose property is sought to be
Sir, you
broken
don't
down.
need to make any submission at all. I have made my observation.
My lord,
Isn't
that
it?
person has not filed any writ
Give them
petition.
2 days, I'll keep it next week.
My lord,
my lord, my
Personal
lord,
issue
my
is
lord, my lord,
Yes, my
my lord, my lord. We will.
At all.
Just only we thought it that to brought your lordship's notice. I don't have any, my lord.
Exactly what I said. Your authority doesn't think what is necessary to be thought. They think of extraneous things which are not necessary at all.
My lord, we are still, my lord, I am bar down, my lord. My lord, what my officers thought it, because these what the remedial is.
Think less and act more.
My lordship, I will.
Affidavit in compliance submitted on behalf of the alleged contemner is taken on record. Contemners is taken on record. Paragraph.
And my lord, one thing,
Very strange to note that the order under contempt has not been complied with merely because of the fact that one of the encroachers, alleged encroachers, has filed a writ petition which is pending. It is pertinent to note that the learned writ court has chosen not to grant stay of operation of the order under contempt in the said writ petition. Paragraph. Learned counsel for the alleged contemners submits that the order under contempt shall be complied with in its entirety upon removal of all encroachments in the plot in question within 2 days from date.
3 days. My lord, make it 3 days. Police arrangement, I will see.
Within 3 days from date.
Today is Tuesday, my lord.
Paragraph.
Friday, I will complete it.
Paragraph. Let the matter appear under the same heading on Monday.
Lordship, I will appear virtually after the compliance, my lord. After the compliance.
my lord, kindly keeps it on
Because
Tuesday,
ruling
my lord.
should on your
No, my lord, because this was your, my lord, I understand unless this has some persuasive value, because this is the reason I have chosen to appear personally, my lord. With very candid, my lord.
your authority doesn't comply.
My lord,
you
my
are
lord,
talking
kindly
about
see
persuasive
your
value.
lordship, my lord, may I? Your lordship said to pass a final order. I passed a final order. But my lord,
That's
it is their duty to demolish it, my lord. It is their duty. They have not demolished it, my lord.
Whose
I have,
duty to
my
demolish?
lord, the encroaches. This said to fight.
If they don't demolish,
Then that's what
left to their mercy.
in furtherance to the, that's why, my lord, we have stepped into.
And opine that a writ petition is pending, so let it continue.
My lord, this is the words we have traveled with this word. My lord,
I am sorry to say that this
my lord,
smells
I said that Millers are wrong.
of extraneous considerations.
My lord,
I'm really sorry.
no, my lord, my lord, it is not, my lord. Otherwise, I wouldn't have said.
Do not know why on earth this decision has been taken.
Tuesday, my lord, when your lordship will be
Monday.
Monday, lordship. Grateful.
Kindly keeps it on Tuesday, my lord. If it is my lord.
You have difficulty on Monday? Very well. Tuesday is
21st.
21st.
My lord.
On 21st May, paragraph affidavit of compliance be submitted on the adjourned date, comma, in default rule be issued.
My lord, your lordship has recorded 3 days, my lord. Your lordship.
Within 3 days, yes.
Lordship recorded 3 days.
Compliance within 3 days and affidavit of compliance on Tuesday.
Lordship.
Otherwise, I'll issue rule.
Lordship. Grateful, lordship. Much.
Next. Yes, list, please.
Grateful.
Your lordship's.
No, appellate side.
Item number 1 to be mentioned.
Oh, how much? Invitation. Moonlight Express.
Yes, this is for
Yes,
extension.
yes, madam. I have served notice. Moonlight hai aaj?
These are the evidence. There was a direction to use opposition, my lord.
Have you served?
Moonlight.
Sir, I have received.
Yes.
No, probably, my lord. This is a railway matter, my lord, for extension of entry mode.
Yes. This is a different writ petition
Oh,
that you are submitting. The first matter is 12139.
I'm sorry.
এটা ফেরত দিয়ে দিন।
কি করে দেবো গো?
ফেরত দিয়ে দিন।
তুমি তো ভয় পাইয়ে দিয়েছিলে।
Yes, who is appearing for the railways?
My lord, I am on behalf of Union of India.
Yes,
My lord, I
yes.
have served notice, my lord. Pleadings are complete, my lord.
I'll fix a date for hearing.
Lordship, early date, my lord, a very early date, my
Lordship,
lord.
after vacation fixed another, kindly any day.
Obviously.
My lord, this is the notice, and my lord, I have made my submission. So far as my submission is concerned, my lord, I have concluded it.
There.
Only his response is awaiting, and I have served notice.
Let it be extended for a limited period.
And my lord, early date may be fixed for a disposal.
Learned counsels for the parties. Paragraph, let the matter appear under the heading Group 7 hearing on 18 June.
Yes, great.
One matter is fixed on 21st, your lordship, kindly take it up after 21st.
No, my lord, I have a strong objection, my lord. Because of the reason, my lord, I am suffering, my lord.
Come back the next week, 25th June.
Lordship.
25th
My lord, they should
Paragraph,
be.
interim order granted earlier is extended till 31st July or until
Lordship.
further orders, comma, whichever is earlier.
25th June, man.
And 31st July interim order. Next.
The Group 7
Item
hearing,
number
my
2.
matter, my lord.
Give me a minute.
Group 7 hearing.
Yes, the earlier matter. Yes, I've recorded. Yes, next. কোনটা?
এটা কত 2 ডাকলো
965 or
2 দিদি 2
who is appearing?
মানে in this matter
Wrongly recorded.
মানে list মানে contain my matter but my lord file contain মানে different matter.
You have stated wrong the number
This
wrongly.
is not my letterhead, my lord. My name is my lord Somunath De, my lord, which is appearing in the my lord cause list. And my matter is 23 matter. And this is my lord 2022 matter.
You are the petitioner.
No, my lord, I am not connected with this matter. I, my lord, came before your lordship, my lord, to see the cause list. In the cause list, my lord, it is appeared my matter.
It's a bull number. No order need be passed for him.
আমার না ওটা লিস্টে তো আমার নাম লেখা আছে, আমার কষ্ট টাইটেল আমার সব লিস্টে যা লেখা আছে সেটা সব আমার।
এইটাতে না 23 চেয়েছে এক্সটেনশন 23 চেয়েছে এক্সটেনশন আপনারা ভুল নাম্বার দেয়নি ফাইল ভুল এনেছেন আপনারা হ্যাঁ এখানে 23 আছে ফাইল 22 এর এসেছে নট টুডে করছি কালকে ঠিক ফাইল যেন আসে দেখুন 23 চেয়েছে ফাইল 22 এর এসেছে রেকর্ড হয়েছে 23 কিন্তু ফাইল এসেছে 22 No order. The mentioning slip shows a wrong number.
My lord, that is my lord, wrongly my lord, I my lord, to see the cause list.
I
my lord,
understand, that's all.
appear.
No order need be passed.
My lord.
Yes, next.
Item number 3. Time for the petitioner.
Lord, I am for the Million Development Corporation, led by Mr. Shah.
Gets to opening of the portal, and in the meantime, ADN has passed the order, and my lord was pleased to grant stay on that order, and that was extended to time to time.
My lord, your lordship, will I file the instruction, my lord, I told your lordship.
May I have the copy?
দাঁড়াও বাবা, my lord,
You will have a copy, don't worry.
এই নাও।
Let the interim order be extended for a limited
And my lord,
period.
fix the hearing.
No,
Yes,
hearing.
Motion.
Motion.
I'll fix
That
it.
is motion. Yes, my lord.
Kindly fix any day after vacation because my lord monsoon is coming, my lord.
The thing
My
is that,
lord, his first prayer is my lord to consider the representation.
no.
My lord, the thing is, the difficulty is that, my lord, only more than 1.5 crore I have invested. ADM referred for opening a portal, which was refused by the MMTCL. That is the short case, my lord. I pray before you some preference for opening week, my lord. So, but
I'll put it
otherwise,
in
my
the
lord,
opening because,
otherwise, my lord, the entire investment will be wasted, my lord.
Instructions submitted by the state respondents is taken on record. Paragraph, heard learned counsels for the parties. Paragraph, let the matter appear under the heading Group 1 motion on 13th June.
Yes.
10th, we are reopening.
Yes, ma'am.
Paragraph, the interim order granted earlier is extended till 30th June or until further orders, comma, whichever is early.
13 June, my lord. If you
13th June hearing, 1-3.
kindly fix the time, my lord.
Order not possible in this court, you're aware.
Then, my lord,
Item number 4, contempt application.
I appear for the petitioner, my lord. Pursuant to your lordship's direction, my lord, we have served, my lord. Lord, page 50 is your lordship's order, my lord. The direct purchase matter, my lord.
Who is appearing for the contempt? First, second, and fifth respondents.
My lord.
Who are they?
Mr. They appeared during Chile. South 24 Pargana. And Hubli.
My lord, give me a copy, I can look. Give me a minute.
Achha, state
Right order identical method.
All of them are two. You,
well,
where is the third service? There are three contemners.
Two contemners.
1, 2, and 5.
Malad, I am told, Malad, so far as the fifth respondent in the writ petition is concerned, Malad, he was not available, address was incorrect. So, Malad, he had been not made a
Executive
party.
engineer.
Malad. He has not been made a party in this contempt application.
So, only two.
Two, Malad. But in similar matter, Malad, my lord has passed this order. Malad.
But no one is appearing. Let Mr. Dey take instructions. Mr. Dey was appearing in the...
In the writ petition, he appeared. Malad.
Give this to me on the next day.
Malad.
এটা ফেরত দিয়ে দিন তো এদিকেও শুনতে হবে তো
কবে আসবে আচ্ছা নাকি
না না
কবে আসবে
affidavit of service paragraph and accommodation is sought on behalf of the alleged contemners. Paragraph, let the matter appear under the same heading on 18 June.
Right.
Mr. Dey, please take instructions in the meantime.
Yes.
Next.
Item number 5.
Lord 5, I am appearing on behalf of the state respondent.
Served?
State respondent, my lord.
Yes, have you served?
The extension judge.
You are the state.
Yes.
Who is appearing for the petition?
Restoration application.
Is this
Restoration application, my lord.
Someone should appear. For a restoration also no one appears.
Restoration of this space.
ওরা বাড়িতে দেখেছি
None appears for the petitioner, no accommodation is sought. Paragraph, the applications being can 1 of 2024 and 2 of 2024 are dismissed for default. Next.
Well, I appear for the applicant. Well, in this matter, there was direction for filing affidavits. Well, only yesterday, the read petitioner served me a copy of
And there
their
is a
affidavit.
delay.
Well, I some time be
Need to file a reply.
my lord.
But only thing was interim order is required to be extended.
Well, it was up to June.
Because
So it's there.
No, but what happened was state has also already exchanged the affidavit. We will also file the reply against the writ petition. Therefore, my lord, now it will be, my lord, appear for hearing, my lord, because state has already given opposition. We will file
Hearing of the application, isn't it?
writ petition. Main writ petition, they have filed opposition.
But there's an application for addition of party. I think.
Additional party by them.
You're objecting to it.
Yes, my lord. Because according to us, they have no locus standi to file the application. my lord.
Well, I am praying some time be given for filing reply.
Our case was that,
that
my lord, without
because-
initiating any proceeding, my lord, our land has been, they are trying to make construction over our land. Now they don't have any right according to us because they also did not produce any document. Now they are trying to interfere in the matter, my lord.
Well, the road was since last 40 years, and they are claiming.
Affidavits in opposition to the writ petition. Fine.
to the application.
There is two
Matter.
Two writ petitions. One is Moonlight Residency.
6 and 7.
Another
6 and
one
7
is
both.
Pramshu Infracon Private.
Act-
They have
act-
been
act-
taken up separately.
একটা করে দে তো তো দুটো সেপারেট
sorry.
বিল হবে না
13361 is this petition. WK along with
only one
can
submission.
1 up to 4.
Only one submission. If you see the last order 4th April, kindly see once.
Yes.
The name of Mr. Bhattacharya has been recorded twice instead of my name. Debru Bhattacharya.
Two different spellings
Hey,
though.
ওটা বাজে। But twin.
LS.
My is
Not
Debru
after-
Nowadays, it is very
Get
easy to
error
find out who is appearing in the matter.
Accepted the order passed on in the cost title of the order. ওনার একটা নাম বাদ দিয়ে একটা দেবদীপ করে দেবেন।
তোমার আমার নাম লাগবে নাকি দেখুন এত খারাপ অবস্থা
Affidavit in opposition submitted by the writ petitioner. Affidavits in opposition করুন। The applications being can 1 of 2024 and 2 of 2024 and affidavit in opposition submitted by the respondents in the writ petition are taken on record.
আমরা কষ্টারি
Paragraph on prayer of the applicants, comma, a liberty is granted to use an affidavit in reply to the affidavit in opposition used by the petitioner. Now, petitioner. Application.
But kindly grant me 2 weeks time.
A paragraph, let the matter appear under the same heading on let it appear on 14th June because till 15th the interim order is.
Very good.
14th June.
14 June. And next one is same also. Next matter is
next matter affidavit
But could it be not subject to your lordship's judgment?
Yes,
Could it be at 2 p.m.?
সকালে টু মেনশন থাকলো
2 p.m. because group 7 matters are taken up at 2 p.m.
At 12, blood, if your lordship should deserve.
Yes.
At 12, at 12.
I'm
Plus,
not fixing
subject
a
to.
date. Let it appear. Let us see. I'm not fixing the time. In this court, it's difficult.
next matter affidavit
7
7 is same.
same matter I'm filing the affidavit in opposition
to the
to the
application.
can application my lord right Nidhi
Same one.
I'm grateful to you.
The seventh milord already milord file application opposition.
Yes, I recorded.
Yes. যাবেন ওটা আলাদা করে দেবেন 6 এর সঙ্গে দিয়ে দিয়েছে হ্যাঁ
হ্যাঁ হ্যাঁ ঠিক আছে ঠিক আছে দিয়ে দেবে দিয়ে দেবে
Next.
চিন্তা করবেন না।
হ্যাঁ হ্যাঁ
8.
দাও, এখানটা বুঝতে পারো। নামটা লিখে দাও
I'm appearing for the state respondent. Appeal is already pending before the division bench. You have taken all steps, mentioned the matter before the division bench. It will come on the next week.
Lordship, against they had filed the appeal against the interim order. If the matter was heard and finally disposed of, then there is no question of appeal. Even though Lordship, in the last occasion, your Lordship, in the March 24, Lordship, that Lordships was pleased to extend the interim order till 30th April, Lordships. And Lordships, and they had filed the appeal, even though they had not the restored, that was also dismissed for default in this appeal. So appeal in respect of the interim order. So there will be no but to heard the writ petition.
No. We have mentioned it on 22nd April 2024 before.
This is against the interim
Earlier
order.
that was dismissed for default. Mentioned for listing.
Appeal against which order?
Appeal against interim order.
Let that be there. Please let us
Yes.
look at the writ petition.
Writ petition.
There is no difficulty.
No difficulty,
Please
Lordship.
place your case.
Lordships. Lordships, the matter is that the Lordship, the concerned authority floated an e-auction in the year of 2018. And that particular e-auctions, your Lordship, the concerned authority auctioned the 13th block, sand block, in the river of Subarnarekha. And I am the one of the participant. I have successfully participated and successfully I am declared as a H1 bidder. And in Lordship, in the writ petition,
Joint inspection with.
yes, Lordship.
That order we challenge.
That
order we have challenged that interim order before the division.
Show me what you have challenged, sir.
এটা কোথায়?
Order.
ম্যাট আমাদের ম্যাট
Yes, Lordship.
আমাদের ম্যাট
Interim
কোথায়?
order
ম্যাটের
is
কপি
different.
ম্যাটের কপিটা কোথায়? ম্যাটের কপি
I will show you, Lordship, that how their first act.
Joint inspection has been done.
Nothing. No communication from last 6 years. No communication made to me.
There was a direction for joint inspection. Have you done that?
And the others miners are mining in this particular plot in the same matter, your Lordship. I will show you, Lordship.
Challenged.
They had challenged the Lordships, that is the coordinates bench.
Which order? What
If-
is this order? MAT 1137?
I don't know, Lordships, they had.
This is the appeal of the state against the interim order passed by the learned single judge in 2018.
Challenged the division bench order.
No,
Could you do that?
No,
Lordship.
May be pleased to recall the order dated 24th April 2019, passed by the Honorable Justices such and such in division bench.
Actually, Lordship, they also served me the copy of a appeal that is totally.
Challenge.
No, Lordship. Even the total copy of appeal, what they had served me, that is totally wrong copy, incomplete copy they had served. Even though I don't know what they are challenging, they have said that they against that interim order they had challenged. But there is no but to heard the final matter, Lordship.
Joint inspection order was passed by the learned single judge.
Yes.
We have challenged that order, interim order, before the division bench, and that is pending. And we have mentioned it
Not pending.
Next week it will appear in the.
That is dismissed for default already, Lordship.
No. We have
Yes.
again serving notice. We have mentioned it in the 22nd April before the learned division bench.
Yes, Lordship.
And we serve notice to them.
Yes,
The
Lord.
entire order is under challenge. So please come back after vacation. Let us see.
Lordship, they had challenged the interim order. They had challenged the interim.
The entire order.
Entire order.
Order dated 23rd August 2018.
And Lordships, just for a sake, your Lordship, that is the, if your Lordships, for my supplementary affidavit, that is the, come to the page 25, that I had annexed this particular order.
Now he is trying to bring some more
No. Wait for a while.
documents and records.
Wait for a while.
Supplementary affidavit, yes.
25.
Page?
That page 25, Lordship,
Yes.
in supplementary affidavit.
Yes.
In the last part,
Order.
yeah, the respondent number 3 is restrained from taking any further action. Lordship, in that particular document, I will show you, Lordship, how they are continuing, even though Lordships had passed the order in the 21st of March 24 till 30th April, they are continuing with the another auctions process. You just come for a while, Lordship.
Have you filed a contempt application?
No, Lordships, they are.
I have taken verbal instructions from the authority concerned.
I'm
that
just
the land in question, which they are bought in now,
Yes.
is entirely different.
That is, if you want to place, then Lordship, I will place my matter.
Seeking an extension of the interim order.
Yes, Lordship. Even just Lordship, for a sake, for a while, page number 69, you just, because they are auction, they had floated an e-auctions, Lordship.
Have you come up in contempt?
No, Lordship.
So this is, you say it is violation of court order.
Yes, Lordship.
You have proper recourse to law. You've not done that.
Yes, Lordship.
Can you make a verbal submission on this? You cannot. You need to take necessary steps.
Actually, Lordship, they had filed for an interim order, for an appeal for the interim order, Lordship.
Have challenged the entire order.
Yes, Lordship.
That is what the stay application shows.
But then Lordship, the interim order should be extended, Lordship, till the disposal.
Learned counsel for the state respondents submits that the order passed by this court on 23rd August 2018 is under challenge before the Honorable Division Bench of this court. Paragraph. In view of the above, comma, let this matter go out of list for the time being with liberty to mention. Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is earlier. Please mention after disposal of the appeal. 31st August.
Lordship, kindly direct,
Take back your document.
kindly direct them to submit a read copy of the original writ petition because it was dismissed for default for long ago.
I had already served the copy also.
After restoration, have you served?
Yes, Lordship.
After
restoration, yes.
Because
With
the
restoration.
No. My junior is saying it has not been served.
Why don't you serve a copy, sir?
My Lordship, I had served with the restorations applications, your Lordships. I had served
Application was served, but the original writ petition
with
was
writ
not served.
petitions also, Lordship.
Do you have any difficulty in serving?
No, not Lordship. I will serve the copy.
Next.
Kindly record it. Otherwise, they will not.
Serve a copy. Please serve a
Lordship, I had.
Next. 9.
অনেক মোটা Lord, I am for the petitioner in this matter. Only yesterday your lordship taken up. That the road which has been completed in spite of the injunction, they did not want to give any compensation to the poor cultivator. If they do not want to give any compensation, let the land be restored.
Or restore. What is
Yes,
your
or restored.
yes?
Earlier I have given the report again and submitted.
You wanted to restore.
Yes.
At 6 months I have taken straight for time.
How much লাগবে?
লাগবে না 6 months.
The authority wants
Till
to-
restore, till restore, they will give the crop compensation from 2008 to till restore. The crop compensation you have to give it.
Since you are utilized.
You utilize. Yes.
The road is not utilized.
Yes, the road is utilized.
If it is not in your possession, there is no question of restoration. Since you are agreeing to restore, that indicates automatically that it was in your possession all throughout.
Yes, ma'am. Crop compensation has to be given from 2008 to till
If they
restore.
want crop compensation, then they have to file a new appraise.
New. Why new
They have
appraise?
the crop
I want to,
crop compensation prayer is not there.
not there, but
My
this
lord
is the
has given you two
situation.
options. I have.
Well, this
I
is
have
the
already-
situation.
I have
My
told them
restriction is any
I
other
have
or
we will restore it as far as practical. Now, if they want crop compensation, they will
Yeah.
file a repetition appraise
No, there
and
is
pay for the crop compensation. What is
there is also a prayer, my lord.
There is no prayer for damage
There is
compensation.
no
No,
prayer.
well, there is also a prayer in the writ petition. Any other or further order or orders your lordship may deem fit and proper. If your lordship deem fit and proper, that the cultivator, poor cultivator will.
Damage compensation for the
Let
period
them
of
pray
occupation.
by a specific prayer.
The
How
court,
much compensation I have to pay? Let them.
Well,
make a
then the
repre-
agriculture,
let them make a
agriculture officer is
representation.
there. Agriculture officer will serve the report to them.
আগে representation দিন আপনি representation should be given
Court,
for a compensation.
court
Then I am
will-
restoring it.
court will decide it.
That is a
This is a prayer of mine,
action, man.
not different cause of
not a
action.
different cause of action.
Not different cause of
How much
action.
compensation, how much will be the crop
That
compensation?
will
be
agriculture,
decided by the
agriculture officer will give the.
That will
Well,
be
let them
decided by
make a
the authority
representation to
in terms of the present market rate of the land.
Yes, Mullah.
let them make a representation to the rest.
They will not give
That
compensation.
my
They will
crop
not
is so and
compensation.
so, my crop is so and so, I will ensure.
And also, what they did, this is the money of the Pradhan
The
Mantri
authority
Sadak
of
Yojana.
opposition inform the petitioner. The primary grievance of the petitioner is that petitioners is that their land has been
Report file very carefully.
taken on the earlier date. শুরুতে করুন report submitted on behalf of the Jela Parishad. Yes, Birbhum Jela Parishad is taken on record. Paragraph, the primary grievance of the petitioner is that the Birbhum Jela Parishad has taken away their land for construction of a road without acquiring the same by due process of law. Paragraph, placing reliance on the report submitted by the executive engineer within bracket P and RD, bracket close, comma, WBSRDA, comma, Birbhum Division, comma, yes, yes,
You want to leave.
learned counsel for the respondent,
That's our
for
junior.
the learned counsel for the Jela Parishad submits that Mr. Bottomell is appearing in this matter, but yes, but the Jela Parishad is the answering respondent. Submits that the authority shall restore the land of the petitioners to its original condition within 6 months from the within 6 months from 11th March 2024. Comma, that is, comma, within April, May, June, July, August, September, within 11th September 2024. That is within 11th September 2024. Paragraph, in view of the above comma, nothing further remains to be adjudicated in the writ petition and the same is accordingly disposed of. Paragraph, the Jela Parishad is respondent number.
Jela Parishad. Quran 5. Birbhum 4 and 5. Both Jela Parishad and Birbhum.
Birbhum Jela Parishad is the office, so only 4 can do.
Sabadipati Birbhum Jela Parishad.
Not Shabadipati. Executive engineer.
Executive.
But he is not included as a party.
No.
So I think please add him as a party.
Yes.
I'll direct him.
Or your lordship can direct the appropriate authority.
No, no. Against whom will the contempt lie?
Here and now,
The executive engineer within bracket P and RD, comma WB SRDA, comma Birbhum division, comma Birbhum Jela Parishad, comma being the ninth respondent here in comma is directed to restore the plot of the petitioners to its original condition within 11th September, 11th September 2024. Paragraph, stop. Since the land in question was in possession of the Jela Parishad, has been in possession. Since the land in question has been in possession of the Jela Parishad, for which the petitioners were restrained from utilizing the same comma, the ninth respondent is further directed to pay damage compensation to the petitioners in respect of the said land for the period during which the land has been in possession of the authority. Stop. Such damage compensation shall be assessed by the authority upon affording reasonable opportunity of hearing to all concerned, including the petitioner, and shall be disbursed in favor of the petitioner within 2 months. Yes?
There is already, there is a direction to restore within 6
Well,
months.
within the same date. Within
6 months.
11th September 2024. Disposed of ওই 4 লাইন থাকে একদম শুরুতে করুন on prayer of the petitioners liberty is granted to implead the executive engineer পুরোটা দেবেন বীরভূম জেলা পরিষদ পর্যন্ত যেটা 9th respondent বললাম as respondent number 9 in the writ petition paragraph the cause title of the writ petition be amended accordingly.
To appear below on behalf of the petitioner before your lordship.
Yes.
As per your lordship direction, my lord, I have already filed my supplementary affidavit by annexing the my lord, report submitted by the respondent and also exception filed by me, my lord.
Yes, yes.
My lord, would your lordship kindly allow me to my lord, move the matter by physical appearance on 28th, my lord, then it will be my lord, helpful to me, my lord. That is, it is required to appear physically before your
That
lordship.
case, please come back after the vacation.
Your lordship on 28th,
Matter
your
needs to be
lordship will
heard.
take
It's
up
been
on
for a
matter.
very long time.
No, 28th, my lord,
Next week will not be possible. Next week will not be possible. Please, when can you come after vacation? I'll fix a date. Can it be 20th June?
My lord?
20th June?
Yes, yes. At your lordship, my lord.
Yes?
Yes, my lord. At your lordship, my lord, 20th June.
20th June, can you come physically? I'll
My lord.
fix.
Yes, 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 I shall. Grateful to your lordship.
On prayer of the Vashu, on prayer of the petitioner, the matter is petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 20th June 2024.
Deeply obliged to your
It's
lordship.
pending for a very long time. It needs to be heard.
My lord.
Next.
এটা কার নেই
Yes.
দাদা একটু ওদিকটায় চলে যাও this is my application this is against the non-payment of interest from the date of taking over possession to till the date of award under section 80 of the Right to Fair Compensation Act. This is admitted position by the competent authority
that I am entitled to the benefit of 2013 Act. And there is no appeal from the Metro Railway. Now, award was competently assessed the compensation granting other benefits, but saying that I am not entitled to any other benefits in terms of that act. And my lord admitted the possession was taken over before declaration of the award.
Position from 26th August 2019. And the compensation paid on?
Compensation paid on.
Malan, we paid the compensation on 14th of March 2019. And the possession was taken on 26th of August 2019. Malan, we have affidavit has been Malan affirmed and again on record.
Just matter kindly take up my writ petition. Page 49.
Received a copy?
We have given the copy.
Yes, sir.
Affidavit.
Yes. Now, my lord, kindly have a look at the, my lord, the page 49. Page 49 of my writ petition. This is the letter from the Railway Vikas Nigam Limited.
Yes.
It is through RTI.
Page 49.
Page 49 of my writ petition. There is an annexure, continuation of P6. P6 starts from page 48. Can you turn to page 48 first?
No, this is the order of the Metro Railways.
No, my lord, this is 4663 of 2020. 2020. 4663.
4663
Yes.
2020, yes.
My writ petition. Eto Deven Didi. My lord, can I check it from your? That is annexed at P6. Page 48.
No, annexure P6 is something else.
देखिए दीजिए तो brief देखिए. May I search for your lordship?
P6 is the RTI.
Yes.
Page 52.
Oh, page 52. I'm sorry, my lord.
Yes.
Now, my lord, the reply is like this, my lord. The verbatim remarks of the executive pertinent to your RTI query is enclosed for kind perusal, please. Verbatim. Now, kindly turn to the next page.
Page 5, 2016.
Now, my lord, it has been submitted on behalf of the railway that possession was taken over in the year 2019. I was compelled to sign that document. Earlier, your lordship in the RB dealers, your lordship dealt with this matter. I was compelled to do so because otherwise they would not have handed over me the check. Otherwise, my lord, there is hardly any scope for handing over the possession because notice is to be served upon me. Then only I can hand over the possession. And that is not the case. That notice was served upon. There is no whisper and no document has been submitted before your lordship. This is the notice that has been served upon me, and pursuant to that notice, I have handed over the document. And they cannot ignore this. This is the letter of the Metro Railway, of the authority. That is not my statement.
Yes.
My lord, what affidavit has given,
Yes.
my lord, in 2012, one notification came out for Taliganj, Karya. What was the thing in that, my lord? In 2012, that is on 25th of January 2012, under Section 7 of the Metro Act was 1978 was being issued, where a small portion of land was being taken. There were two survey done. One was at Gargacha and one was at Bridgie. In Gargacha, 4,500 square meter were to be acquired. And in Bridgie, it was to be acquired is 3,000 square meters. The reason for acquisition was, my lord, in regard to building up a station building of which is now known as Kavish Bahas, the Garya station. That was the object into that. And that thereafter under Section 10, my lord, on 16th of January 2013, under Section 10 was being issued. So the process started with. Now the water notification has come up here. It is in not regard to TG, my lord, not Taliganj to Garya. It was in regard to NGA, means New Garya to Damdam Airport, my lord. All the cases, in 17 cases, there are 16 cases which relates to NGA, not Garya to airport. Whereas one case is there which comes under the notification of 12. So NGA notification came up, my lord, on 22nd of March 2013, where it has to cover out around 9 mojas, 2 districts, North Chobis Pargana to South Chobis Pargana, where lot of thanas were to be inquired, because that was in regard to laying a new line between the New Garya to airport, my lord. Thereafter, my lord, on February 2014, under Section 10 was being issued. In this case, my lord, they are all family members. They made out an objection. 21 people were there who had made out an objection in regard to that. One objection was in regard, that is TG, that also got included into that because she was wife to one of the person in NGA, my lord. So the construction of the building started with, my lord. When the construction of the building started with, thereafter, my lord, if you see, my lord, in my application, first I come out with the notification, my lord. It starts with, my lord, from page number 6, my lord. The first notification of TG.
In today's application?
Yes, ma'am. Before also I had said this thing, but specifically I have come out with a notification, my lord. It starts with the English version. It had page number 7, ma'am. Page number 8, 10, my lord. That notification of TG is on 25th January 2012, SO 158, my lord, where land, building, street, road, passage, and nala and the right of the user therein mentioned in the schedule are required for the purpose of construction of metro rail and other works connected therein into the city of Kolkata. My lord, is this only the portion this is I'm reading because it's important. Now in page number 11, my lord, the 2 surveys are there. The one survey is there in Gargacha, my lord. If it has been seen, there are 3 darks, 4,500 square meter is the area which is being taken over. Now in the second survey, it is Priji, my lord, where 3,000 square meter were to be acquired, my lord. Now kindly come to page number 12, my lord. Section 10 was issued when, my lord? That is on 16th of January 2013. At the page number 13 is the English version, my lord, where SO 175 was issued, where the notification of the Government of India and Ministry of Railway issued under subsection 17 Metro Railway such and such. Intention to acquire land, building, street, road, passage, and right to user, my lord. So in the next page in 14, my lord, the 2 surveys there. At the schedule says brief description at page number 14 of the land to be acquired with or without structure for the purpose of construction of metro railway from Taliganj to New Garya and other works connected there in the city of Kolkata of state of West Bengal. Now, my lord, the second notification, the second acquisition, that was of NGA, New Garya to airport. That starts out from page number 15, my lord.
It's a Hindi version, the 16 is the
The
English
land
version.
of the petitioners fall within which,
My lord, this
Both
what
notification.
I'll come out to the picture, my lord. They showed us the picture in regard to the building constructed under TG. I'll come out with the facts, my lord. All the things are to be said, my lord. Under page number 16, my lord, the notification under section 7, where it is very specifically said, SO 827E, whereas the land, building, street, road, passage, or right of user or easement therein specified in schedule are required for the purpose of construction of metro railway from New Garia to Temur station of New Garia, Damdam Airport project. So this is totally a different, which was not in regard to that matter. Now page number 17 says out the schedule matter. Only turn out to page number 17 matter. Schedule says out what, my lord? Schedule of private land to be acquired in connection with the construction of the metro railway line in between New Gadia and Damdam Airport. So that was not in regard to purpose. It was specifically set out for a new line, which has to be done out in regard to from Garia to Damdam Airport, my lord. Now, first is Moda Balia. That comes under South Chobis Pargana, my lord. Second is Gargacha, South Chobis Pargana. 3 is Briji, South Chobis Pargana. Page number 18, my lord. Mauja, Patoli, South Chobis Pargana. Number 5th is Chak, Maska, South Chobis Pargana. Topsia, South Chobis Pargana. Purba, Topsia, South Chobis Pargana. Dhapa is South Chobis Pargana. My lord, in 9, page number 19, Moja, Batan is North Chobis Pargana. Moja, Gote is North Chobis Pargana. This was the schedule that was under NGA, my lord. Now, my lord, under section 10, the notification was issued under the same NGA, my lord. That English version is at page number 21, my lord. Page number 21.
in both the acquisitions, Moja Goragacha is
It's South
involved.
Chobis Pargana. Gargacha is South Chobis Pargana. Because, my lord, if I see.
So in both the acquisitions, this Moja is there.
Yes, madam. In the first notification also it was part. Dark number 80 was in TG also was been acquired in a part. And as well as if we see into this, lot of darks are there in NGA. 80P was also there. So it was a big dark into that. So my lord.
My lord, first repetition that I am moving, that is plot number 2.
My lord, page number
Says plot number 2.
My lord,
come one by one.
RS Dag number 2, yes.
2.
Yes, madam. Page number 20.
So here, where is RS Dag number 2 in the notification schedule?
Just a second. Gargacha, my lord. Dark numbers are being, yeah, my lord. 80 part at the second Gargacha, my lord. If I come into 1 part, 2 part, at the from bottom is the second last, my lord. In second, Moja Gargacha, my lord. 80 part 206.766.
You are at page?
Page number 17, my lord. That is section 7, the notification was issued.
Yes, 2 is, serial number 2 is Goragacha.
Yes, ma'am. And in Gargacha, if I go, from second last, if I go in the column, my lord, it can be seen revisional state settlement, cadastral survey dark number. In that column, my lord, if we see in that from the last 81 is there, before is 80. So total is 206.766 is
No,
the
it's
area.
Dag number 2. So the first Dag, 2 part.
Yes.
It's Dag number 2.
Yes.
No, part 2 no means, but my lord, if we come out from the last, second last.
And this is NGA. This is not the Tollygunge method.
This is NGA, my lord. This is NGA. If we go into TG, my lord,
so the petitioner's plot here is within NGA.
NGA is there, even in TG also.
No, their plot number 2 is not there.
Page number 14, my lord.
Yes.
Page number 14, my lord.
Yes, 14.
That is New Garia. That is Taliganj to New Garia, my lord. First, survey number 1. Moja Gargacha, Dag number 59P, 65P,
Two is not there.
80P.
So petitioner's land is not involved here.
My lord, that was being done. All together, what they are claiming, my lord, they never had been taken at that time. Never the construction was done out only in the Dag, which was being taken in TG. The photographs what they have given, it is of the building which was being constructed for the station. That was taken into plea. And if I go into the RTI, my lord, if I go into the
You
RTI,
cannot distinguish between the station, line, things like that.
my lord,
It's the
new-
metro railway construction.
my
which
lord,
includes everything.
my lord, let me come out with a new line. This notification was issued. One by one, I'm coming, my lord, because things are to be, this is confused.
Difficulties, you're dealing with all the writ petitions
My lord,
together. Please don't do
Yes,
that.
my lord, it's been
Please
confused.
deal with the first writ petition
My lord,
first.
I'm staying with the first writ petition, what I have submitted, my lord. Kindly allow me to have out a clear picture of that. But the confusion is being there, taking into two notifications, which was not to be taken. NJ was involved into
In
TG.
the first writ petition, the first notification is not applicable at all.
My lord, not applicable.
Only NJ is
Not
applicable.
applicable. Only in one case it is applicable. Only in one case. Apart from 17, 16 is been there. But what is there? They took the advantage of the TG which they shown out because the construction in TG was being done. What they have been showing.
Your
My lord, I'm coming to the RTI. RTI, I'm coming, my lord. RTI, I'm coming, my lord. Kindly allow me to have out.
you are making it very elaborate. Please come to the point.
Yes, ma'am. Kindly come to the RTI, madam. It is in page
Yes.
number 33, madam. What the one person named Debrodo Chandra, madam. He is not a petitioner here. He made out an application of 5th of November 2019, madam. The general manager, what he has asked out, my lord, under RTI, page number 33, madam. Please inform from which month. My lord has got out an RTI?
Yes, yes.
From which month and year the construction activities of the proposed Kavi Subha station building. What was the RTI asked out, my lord? It was in regard to the Kavi Subha station building, my lord. But he added out what? Started for the extension of metro rail project from New Gadia to airport. But my lord, in regard to the building was being done out in TG, my lord, not NGA. So he made out an RTI where he asked out when that building station was being done. Now I have kindly come to the answer what we gave out, page number 27, madam. On that RTI, a question was being raised before RVNL, not Metro, madam. RVNL is not the party here. Madam, the reply was construction activity of Kavi Subhas. What we made out a statement, madam, in regard to the station building. We did not make any question out, made out an answer to the new line. We said out construction activity of Kavi Subhas station building for extension of metro railway project from New Gadia to airport was started from 10th May 2016 in the acquired line of metro rail within the existing railway boundary. It was not in regard to the new line, Mala. Altogether, it was a question raised out in regard to the construction of building. Kindly come to the writ petition, Mala. Page number 53C, Mala.
The station building is also part of the metro railway project.
Mala, that was done out in TG, Mala, not to NGA, Mala.
Your reply doesn't say so.
My lord, I have written in my reply.
There is a
My
single
lord, I have
station.
given
Page 53 of the writ petition.
the photographs also. My lord, we have given the we have
Kavi
specific.
Subhash building for extension of metro railway from New Gadia
No, my
to
lord,
airport.
What, my lord?
Page 53 of the writ petition.
53C. The
The
photograph.
station building
The
is for
photograph, my lord.
extension, not
My lord, the
photograph.
53D
reply.
photograph.
53 of the writ petition.
Yes, 53D.
I'm not on the
ABCD.
photographs at all. I'm on.
I have been given a
your
photograph.
reply. It is your reply where you admit that the project started from 10th May 16.
That is in regard to the building, my lord.
Building
We made
is
out
part
a
of the
building.
project.
My lord, it is a question what has been asked, my lord. Kindly see
Building
the
is part
question.
of the project. You have answered beyond the question also.
No, my lord, the question was asked out in this way. Kindly again turn out to page number 33, my lord.
Yes, please come.
What he has said out. Please inform from which month and year the construction activities of proposed Kavi Subhas Station building started for extension of Metro Railway project from New Garia to airport. He said out New Garia to airport.
So you could have given the reply that this is
My
not
lord,
from
that
New
is
Career to
that is
airport.
RVNL done out, my lord. Metro never gave out that reply. That was a reply made out by RVNL.
Who is appearing for the RVN?
RVNL was never made a party here.
Because I cannot.
Never made
Because
out a
this is
party.
arising out of the compensation.
Yes.
I have a demands against the competent. I have to lodge
My lord, on
complaint
the
against the
basis-
competent authority. I have not lodged against the RBNL.
My lord, on a RTI.
Even if this is by the RVNL, have you challenged this? Have you objected to this, that you have
Yet
given
my-
a wrong
My
information?
opposition in my affidavit, I have everywhere challenged them.
Affidavit, challenge in the affidavit is neither here nor there. You cannot shy away from this.
My lord, it
It
is in regard to the station
On the
building.
RTI reply, he cannot challenge
My
here.
lord, my lord, it is a station
The
building.
appellate authority is something
It's
different.
part of the
My
Metro
lord,
Railway
it is
extension.
nothing wrong I have written. I have written for the station building and never said out in regard to the new line.
Station building for extent. Please read the entire sentence.
My lord, the question was raised
Station
out in
building
this
is
way.
not some railway station building, which is
My lord, is
being
very
constructed
specifically
in an
stated, my
isolated
lord,
way.
construction activity of Kavi Subhas Station building. Very
Please read
clearly.
the remaining part.
Yes,
You're
my lord.
stopping there. Read the remaining
For
part.
extension of, my lord, the station building is with regard to the project entirely. There are two notifications done out, my lord. One notification, if we say it is in regard to the TG, it is also a part of New Career to Taliganj, my lord.
Matters which are not part of this writ petition.
My lord, that read petition, what he has been challenging, my lord.
The
My lord,
MJA notification clearly includes the petitioner's plot, right?
even that TG also
Or-
includes, my lord. Even
No, TG doesn't include.
Yes, my lord.
No, plot number 2 is not
ATP is
included.
there. ATP is there.
That is not plot number 2. Plot number 2 is not
My lord,
involved
it
with
is also 80 part, not 2, my lord. It is 80p. It's been written there. Again,
petitioner's
kindly
plot
come to
is
page
plot
number.
number 2, not 80. Petitioner's
Malik,
plot
Malik,
is
my
plot
lord,
number
kindly-
2.
Malik, kindly come to page number 17, my lord.
Yes. In
My lord-
17, petitioner's plot is involved.
Part 1, part 2, 9, 10 full, 11 full, 12 full, 13 part.
This is the
14
difficult,
part.
sir. Why are you considered with all 13, 14 and all that?
My lord, at the
We are
bottom,
considered
after
with 2
59.
only. We are only considered with plot number 2 in this writ petition.
But here also 80 part is there, my lord.
80 part may be in both. That's not the petitioner's plot. Petitioner's plot is
My
only
lord,
2.
they are asking for 80 part only.
No. Please see the prayer portion. It's only 2. Please see the writ petition.
My lord, 80 is there, 80 part is
Plot
there.
number 2 only in this writ petition.
But my lord, in
So
regard,
empty.
my lord, but whatever, if they are
You are making
taking,
simple
my
things
lord, we
complicated,
have been
sir.
giving entirely on the construction of the building, that is station building, not in the new line. If new line notification was given differently, my lord, so things are there. When we gave out a reply, the question was asked out in regard to the station building. It was never been asked in regard to the new line, my lord. If Devrato Chandra made out an application, we gave out in regard to the construction of the building for the station, not for the new line, my lord.
Repeating your submission, which will not help really.
My lord, I'll come out with the one RTI. The two things which we
The
have.
building cannot be isolated from the Metro Railway work. And we are concerned with the
My lord, I'll place out
Inception of the
one
Metro
where
Railway work.
RTI cannot be taken into account where things are, my lord, RTI reply.
The relevant portion.
My lord, the relevant portion. My lord, page number 9, paragraph number 13, ma'am.
13?
13.
Yes.
In light of the above question for consideration is as to whether High Court was justified in taking note of information merely because it was secured under the RTI Act to be the basis for its conclusion. We are of the opinion that the High Court was not justified and has fallen into error. This is for the reason that the information furnished under RTI act showing the name of the respondent at serial number 301, having obtained 114.80 marks was to select list, which was prepared for the first time, which was subject matter of the litigation has to be set aside and therefore not recognizable.
So it was already set aside, so could not
My
be
lord,
relied upon.
My lord, but
How is this applicable?
But my lord, it cannot be taken because clearly what RTA.
Why cannot it, here it could not have been taken since it was already set aside? Please see the lines, sir. What
My
are you
lord, it was
submitting?
a subject matter, my lord, not the RTI. On the RTI, the engine, the stay order was been given. The entire process of reselection was been done. But when RTI was again given that the marks are higher, in this case, he got out the job again. In that case, my lord, the Supreme Court came out. The High Court came out on the RTA application. They my lord, can you come to the entire application, my lord? It starts from page number 17. I should come out with the relevant portion. How the thing here, the challenge of RTA was not done, my lord. RTA was never been challenged out in this application also. What been done out in the Supreme Court, my lord. Para number 9, my lord. The sequence of the event noted above and the series of litigation between the party, including the challenge, the original selection list by a group of unsuccessful candidates, which led to the formation of reselection committee and the preparation of reselected list.
Where are you reading?
My lord, in page number 7. My lord, the people who have been not been selected, they were not selected people had made out an application, my lord. Here starts out. The sequence of events noted above and the series of litigation between the parties, including the challenge to original selection list by a group of unsuccessful candidates, which led to the formation of a reselection committee and the preparation of reselected list after considering the matter afresh is not in serious dispute. Though the genesis of the earlier select list being cancelled and the reselection list being published was allegation made by the unsuccessful candidate in OA such and analogous petitions that there was a foul play in the process. The fact that the select list has been rearranged based on marks obtained is evident from the facts narrated above. It is also undisputed that the respondent is not one of those candidates against whom an allegation is made with regard to the submission of a fabricated document for obtaining appointment. In fact, this aspect is clear from the order dated 21/10/2014 passed by the SAT in MP such and such. In said order, the reason for justify the termination of respondent is taken note. It is that the respondent has obtained 109.88 marks, which was accordingly placed at the appropriate spot in the reselect list. The said marks was lesser than the last selected candidate in general category who obtained 111.53. Against the above backdrop, it is noticed that the only reason for which High Court has intervened and directed the appealants herein to consider the case of the respondent by the recording the marks secured by her as 114.80 is by taking note of information secured under RTA Act relied upon by the respondent, wherein the minutes stated 31/1/1997 indicated that the marks obtained by the respondent as 114.80 marks and she was placed as serial number 301. The learned counsel of the respondent seeks to justify the conclusion reached by the High Court, since accordingly to him, the information was obtained from official files under RTA Act, and such information would justify the respondent have obtained 114.80 marks is entitled to be selected, which action has been directed by the High Court to be taken by the petitioner herein. The learned counsel for the appellant would, on the other hand, contend that the error is in conclusion reached by the High Court is due to the fact that the reliance was placed on the list which was prepared on 31st January 1997, the detail which were furnished under RTA Act. Though there was a position in the list finalized on 31st/1/1997, the same has been set aside by SAT OA 2792 of 1999 due to the order passed therein. Subsequent thereto, a reselection list was prepared. In the said process, the marks was correctly assigned, wherein the marks obtained by the respondent in Viva Voice is 14.40, which while added to her marks obtained towards matriculation 44.42 marks for 510 marks in the competitive test, the total would add up to 109 of 86 and not 114 of 80. marks as plain. Hence, it is contended that the High Court was not justified in its conclusion. Here, my lord, the RTA was never been challenged. Here also the same thing. High Court came out with a conclusion because the RTA reply was being done there. Even, my lord, if I come out, there is a residuary cut, a constructive residuary cut out. Come out with a judgment with regard to that.
The fact situation was completely different from the present case.
No, my lord, it's totally under RTI. We gave out an entire, my lord, it's a hearsay process cannot take place, my lord. The thing is there, they
RTI is not a hearsay process at all.
my lord, that is because they already has raised out. They did not raise. That was, if I say the award was given in 18 or 19, but their claim says out in May 16, the construction started with. But the competent authority gave out the award when? That is in, I'll come out. What
19.
My lord, it was given on, the award was being declared on 4th of April 2018. Means in 16 that was done. They did not raise out that issue if that was not been settled at 16. They could have raised out the issue.
Why will they? Because they knew they would get interest.
No, my lord.
Why will they raise the issue?
No, my lord, they raised out an appeal later on by making an application. Why didn't they file up the application in this writ petition? Why didn't they file up the appeal application in this writ petition? Even the application in regard to 80, what they have asked out there, they should have annexed into this one, my lord. They did not do out. When the appeal was also decided on 11th of December 2018, my lord. So they raised out the issue. Even if I say, my lord, there are 4 revisions also that was being done, my lord. Can we take into the revisions, my lord? Which was being done. And the, my lord, in revision CO 3091 is one of the case in this, my lord. The General Manager Metro Railway.
This is not in connection with this writ petition. I could not follow what my learned friend is arguing.
This is for modification of the order of the competent.
My lord, here also they raised out 80.
Who is this? The present petitioner?
No, not this present.
No, he should
One of the
argue.
cases
I
there.
can so that I
In
can
N-
reply one by
My
one.
lord, in NJ, one of the cases there. The 4 cases which I have given, these 4 cases are in this 17 writ petition, my lord.
Please let us. We are dealing with the first writ petition, so please confine your.
My lord, kindly come to the writ petition there.
This is not with regard to the first writ petition, isn't it?
My lord, the issue of 80 was being raised in all these civil divisions.
Is the
They
present
raised out in
petitioner involved in this matter that you're handing up?
not this one, my lord.
So please hand it one by one.
My lord, kindly come to the appeal award, my lord. First, the award which was being done by the competent authority, my lord. It end up in 15, page number 15, my lord, 51.
Of the writ petition.
Yes, ma'am.
Yes.
What they have asked out? Claimant claimed another rupees 5 lakhs per kata in the second paragraph for development of land in question and for the loss incurred by due to acquisition of land by OP as stated in para 30 of the affidavit in chief. Here, this authority is to say that due to change of the nature land has been developed and that the so market value of the here, my lord, entire I don't find out anything in regard to section 80. Now, my lord, kindly come to the appeal that was being done and where they come out for the first time for regard 80. My lord, in page number 59, my lord. 59, 60, my lord. Page number 60, my lord.
Yes.
The second paragraph, my lord. During the course of the hearing of the appeal, means the appeal is being settled in December 2018, my lord. And they are claiming what they have claimed out here, my lord. The learned advocate for the appellant also argued for the application of section 80 for the purpose of implementation of interest due to delay of payment by the respondent, Metro Rail Kolkata. Learned advocate for the respondent raised vehemently objection in this regard. In this context, it is considered view of this authority that the appeal is a continuous process of the original case. So, when the claimant has preferred the appeal against the impugned judgment passed by the learned competent authority, Metro Rail Kolkata, then the question of delay of payment of compensation by the respondent does not arise at all in the case of the claimant has challenged the amount of compensation passed by the learned competent authority before the higher authority. So, in the instant appeal, there is no scope to implement Section 80 of the right to fair compensation, transparency, and the land acquisition. My lord, what has happened here? When the award will be passed in the competent authority, they did not file up the application which they have mentioned out in the appeal, which has been mentioned in the appeal. That was a continuous process, means at that time the payment was not done. In not regarding to construction, my lord. If we see the appeal application, that would be more transparent into this, my lord. But thing is there, they had asked out because the appeal here it has been written as a continuous process. So under Section 80, it cannot, because they wanted the amount as soon as the competent authority made out the award. That was the thing they came up. This is a writ petition. They have come out with a new story, which in TG the construction was been done. If I see into the photographs, Malad, the construction of the
This
building.
appeal is with regard to
That is the challenge, Malad. The competent authority.
compensation in respect
Yes,
of
Malad.
loss and
Competent
damage,
authority was being.
not interest.
80 is in there. In regard to 80, 80 is in regard
80
to.
has not been dealt with at all by the appellate forum.
Because while my lord, thing is there, they have come out not for construction. They said when the competent authority has passed out the award, they should have got out the award amount. So here it has been dealt out because it's a continuous process. The award, as soon as it has to be there, when it is been decided by the appellate authority, it can be also will be disbursed. But we did not take the possession at that time also. The possession was never been taken. The possession was taken before all the people who were the interested party, even the RBNL, the AXN, even the competent authority was also there. If he has been under protest, did he make any application in regard to the protest, my lord? The competent authority was, I'll come out with the possession letter which we have been, which has been issued, my lord. So, my lord, I come out with one judgment in regard to the residuary kata, my lord.
Any
Citation.
ballot
Appeal number one.
Report আপনারা copy
ballot থাকতে হবে
My lord, para number 22 is relevant and para number 31 and 32, my lord.
paragraphs
31 and 32. I said over come out.
31 and 34.
32. Paragraph number 31 and 32. And at the last is the last paragraph. 31 and 32 and come. It is page number 22, madam.
Yes.
Mr. Giri urged, relying upon the above decision of the House of Lords, that in considering the expression might and ought, it is necessary for the court to bear the mind that the fundamental distinction between res judicata and constructive res judicata, here that where the former encompasses the matter which is already directly or substantive in the issue in a previous suit between the same party and has been adjudicated upon, the later being deeming fiction according to which a might and ought to have been advanced in the previous suit would be deemed to be directly and substantive in the issue. He therefore urges that the degree of circumspection must be exercised in the application of the principle of constructive res judicata, my lord. Then para number 32, my lord. We are not inclined to decide this question on priori consideration for the simple reason that under CPC, both res judicata in the substantive part of the section 11 or constructive res judicata in explanation 4 are embodied as statutory principles of law governing civil procedure. The fundamental policy of the law is that there must be a finality to litigation. Multiplicity of litigation ensures to benefit, unfortunately, for the degree holder or those who seek to delay the fruits of the degree reaching those to whom the degree is meant. Constructive res judicata in the same manner as the principle underlying res judicata is intended to ensure that grounds of attack or defense in litigation must be taken in one of the same proceeding. A party which avoids doing so does it at its own peril. In deciding as to whether a matter might have been urged in the earlier proceeding, the court must ask itself as to whether it could have been urged. In deciding whether the matter ought to have been urged in an earlier proceeding, the court which have to due regard to the ambit of the earlier proceeding and nexus which the matter bears to the nature of controversy, in holding that a might ought to have been taken as a ground of attack or a defense in the earlier proceeding, the court is indicating that the matter is of such a nature and the character and bears such connection with the controversy in the earlier case and the failure to raise in that proceeding would debar the party from agitating in the future. Now, my lord, last paragraph, my lord. The view in which adopted 41, my lord. Following the consistent line of precedent of rules 97 to 103, order 21 is buttressed by the provision of Act 1958, a claim under section 4.1 to be addressed to the court which passes a decree for eviction. In the present case, the appellant are strangers to the degree they are required to get the claim adjudicated in the course of execution application, which was referable to the provisions of section to order 21, rule 97. Having failed to assert the claim at that stage, the deeming fiction contained in the explanation 4 to section 11 is clearly attracted. An issue which the appellant might and ought to have asserted in the earlier round of proceeding in a deemed to have been directly and substantial in the issue. The High Court was in the view of the matter entirely justified in coming to the conclusion the failure of appellant to raise a claim would result in the application of principle of constructive res judicata, both having regard to the provision of section 4 and 5 of the Act 1958 and to the provision of order 21, rule 97 to 101 of CPC. My lord, RTI, when I say, they took the RTI in 2019 in November, at the end of November 2019. The award was given when, my lord? On April 2018. And thereafter in December 2018, the appeal was being decided. Now they raised out, in the appeal what they raised out? Not the RTI. Because in 2009 comes out after 2018. So in 2018, they made out an application by Devrata Chandra. Who was Devrata Chandra? He got out in regard to the construction of the building. Let me say out. And thereafter, we gave out a reply to that. Now they came out with this new plea. They did not raise out in the competent authority in regard to this RTI. That was in a continuous process whether the payment, which we did not do at the time of award, my lord. Only thing was that they did not file this application in this writ petition also, the appeal application as well as the application in regard to 80. We did not make the award when the competent authority gave out that amount. So that reason they said out, we should get out 80. So the appellate court said out, it's a continuous process. So 80 was dealt out there. Thereafter, when the award and appeal was completely been finality, thereafter they came out with an RTI in 2019. Kindly come to the RTI application when the date was there, Mala. Mala, the date can be taken, Mala, at page number 53 of their writ petition, Mala. Their writ petition, Mala.
Page 53?
Yes, ma'am.
Yes.
That is 30th November 2019. And my lord, can it be taken my this report which I gave out before? That was a report that was being submitted on August 2023, my lord. It was being affirmed in August 2023, my lord.
Not July.
August 2023. One report was given. This is a new report I given. Is their report in the form of affidavit is written there?
It's July 23, not August. I'll just find it. Yes, August 23.
Yes, my lord. We have filed up the appeal in the first part, my lord. My lord, kindly come to page number 16, my lord. First, I should say out the appeal, my lord. It's better, page number 14. Page number 14 is the appeal which that was being came out in the finality, my lord.
Yes.
At the last portion, it can be seen, my lord. The appeal is being, certified copy is 21, 12, 18. The order, the impugned judgment of the order passed by the learned competent authority, Metro Rail, Kolkata, 4/4/2018, my lord. And the appeal has come out to finality. It is on page number 7, 11 December 2018. Did your lordship get it? Page number 7. Now, page number 16 is the check we gave into. Page number 16.
Yes.
That is 14th March 2019. Well, kindly come to page number 17 now. This is handing over and taking possession note of the possession of the land, Sri Bishan M. Agarwal, son of Mr. Rambilas Agarwal, Gargacha, Sonarpur, NGA 18, and published under competent authority, the Gazette 9/6/2013, and the competent authority passed the award on 4/4/2018. My lord, kindly see the signature. First is the Daffodils Residency, the claimant. His signature is there. At the right side, my lord, possession taken over, signature of representative of learned competent authority, which gave out the award on 4th of April 2018, is a competent authority. At below that, Bishan Agarwal, possession handed over, signature of representative of learned competent authority, Metro Rail, Kolkata. At the right side, it is AXEN, headquarter, Metro Railway, for on behalf of Metro Railway, GM. Now, at below, at the last on the left side, possession handed over by signature of representative Metro Rail. Then after, my lord, B. Das is the RVNL. So all the parties were there, my lord. Entire party handing over possession was given, and before that the check was been given. But if I say, my lord, if RTA of 2019 is been taken, it is totally been hit by the constructive res judicata. They did not raise out that issue. And second point is there, still also, my lord, if we say the RTA which was being answered by us, that was in regard to the construction of the building for station in TG, my lord, not connected. Now I'll come out with the, today I find out one report, my lord, this affidavit. Kindly come to page number, where the story started with. I'll come out with this, my lord. Where the story started with, my lord. The story cropped up here, my lord. Page number 26 today, which I filed, my lord.
Yes.
My lord, in one of the case in 17, this is the only case which is of TG. It is written claim case number TG. If your lordship sees out the entire case, it is all of NGA. But this was a TG. What is there, my lord? I put up because it has to be seen, because there the story starts with. Of 2019, the story starts out from here. An application for restraining the respondent, Sarita M. Agarwal, versus page number 26, my lord. Annexer E, my lord. When the claim case was going on in regard to TG 8 of 2015, my lord, the claimant filed out one application. In regard to what application? An application for restraining the respondent from causing any damage to the structure of the petition, claimant in respect of the land situated at RS Dag number 80, corresponding to LR Dag number 87, under LR Khatiyan number 435, is there altogether. I should come to the main portion, my lord, at paragraph number 2, at page number 27. The most illegally, without any authority of law, on 17th of February 2017, some people claiming themselves to be men and agents of the respondent demolishing the boundary wall standing upon of the land in question while in process of construction work in adjoining plot, means it's adjoining to her plot, not her plot, of your petitioner, thus inferred with the peaceful possession of the claimant. My lord, now the para number 5, my lord, at page number 27, that the direction of our respondent be given for not to cause any damage upon the structure, boundary wall of your petitioner while in process of construction work in adjoining plots of your petitioner. Now the prayer says, it is therefore prayed that your honor may graciously be pleased to pass the direction of our respondent for not to cause any damage upon the structure and or boundary wall of your petitioner while in process of construction work in adjoining plot of your petitioner, and to pass necessary orders and orders as your honor deemed fit and proper. Now, what was the order, my lord, passed by the competent authority in this case, my lord? It starts from page number 29, my lord. The order was passed on 5th of May 2017. Learned lawyer for both sides are present. The petitioner of the claimant dated 7/3/17 is taken up for hearing. Put the petition, Han, the learned advocate for both sides, consider. Upon such perusal and hearing, it reveals that by filing present, petitioner claimant intends to convince this authority so that a restraint order may be passed against OP in doing damage to the adjacent land and the properties belonging to claimant, considered work of OP in construction of metro rail is for public purpose and cannot be restrained, and if any damage is caused due to negligence of OP, there is specific provisions of the compensation for damages in this in a special statute. As such, no such order in anticipation be passed at this stage against OP, my lord. So this was the case which they came out. And my lord, if we take into this consideration, my lord, this was when the construction of the station building was taking place, my lord. The adjoining plot of Sarita was being the construction of a building because there were two surveys done, 4,500 square meter and a 3,000 square meter. If we see the photograph of 53D, which the writ petition shows out, clearly states out the building is there. Even all the photographs, if I see, it makes out a picture of the area where the building was being constructed. The adjoining areas were also been developed. That was 3,000 square feet. And where the Gargacha part was there, this was 4,500 square feet, where the building was to be, proposed building were constructing. And Devrata Chandra also made out in 2019 in November, the RTI in regard to the building only, not in regard to the new line. When I say of NGA, when the entire case of NGA comes up with, is all in regard to the new line, which is being constructed between the two districts, having lot of Hanas and lot of Mojas are there. So that was the project here, not the building, my lord.
Building is part of the project, sir.
My lord, if your lordship thinks,
the building from the project
my lord, that is building has been done. We made out very,
for residential accommodation of someone, some private.
my lord, we made out that clearly we stated in our application also.
For the purpose of the metro railways.
My lord, that is TG, but the acquisition is required in TG, my lord, not in NGA. Their land was never been acquired. If we say we never acquired, and even if they have to be there, the award was passed out in 18, my lord. In 16, they could have done out in competent authority. That was not been passed. Even in the appellate also, they could have done out in regard to the construction. But they made out 80 was what? They did not get the payment at the time when the award was being done. It is a new story that came up in 19.
Only after payment of compensation, not prior to that.
What, my lord?
They could have raised this issue of interest.
My lord, they could have raised out in competent authority.
Payment of compensation, not prior to that.
I didn't get your lordship.
Compensation was paid in 2019.
Yes, my lord.
They could have raised the issue of interest under section 80 of the
Before the authorities, my lord.
Before the authority, after the compensation, not prior to that.
My lord, they raised out in 80. They had
compensation.
My lord, is in regard to an RTI in 19. If the compensation were to be given, if the acquisition of we took acquired land in May 2016, what they allege.
When was the compensation paid?
My lord, we paid out the compensation. It's been there, my lord.
Sometime in 2019.
My lord, we paid the payment on 14th of March 2019.
Absolutely wrong. Incorrect statement.
My lord, kindly take that
Kindly see, my lord.
kindly
Kindly
take
see.
into our report, my lord.
A report, kindly have a look at the report. This is my lord. Kindly have a look at the date of the draft. There is 14th March 2019. I can produce the statement before your lordship.
Yes, 14th
Payment
March.
was made to me on September 2019 after signing this document. After signing this document, I can produce the document, my lord.
He signed out on 26th of August, not in September, my lord.
So thereafter I was paid.
My lord,
Thereafter
and
I was paid.
the entire amount, the check is a
lord,
validity of 3
kindly-
months.
My lord, I have
3 months, my lord. If the check were to
Yes,
be,
that
if
you-
I say into my lord,
Yes.
Will not be taken into consideration.
Yes.
The date of payment.
my lord, even if I
Let it-
say, my lord, this entirely, if I say, if that May 2016 story when it has been coming, that time the award was not been.
According to the petitioner, the date of payment is 4th September 2019.
They say.
They say, according to, yes,
Yes.
there's document also, I'm sure.
No, my lord. We have submitted our document in page number 17, my lord.
My lord,
Page number
my lord,
17.
in our supplementary affidavit, I have categorically said when payment was made. In my supplementary affidavit, I categorically said that in paragraph 4, your petitioner said that on September 4, 2019, the competent metro rail authority had paid the awarded amount to 2 crores 81.
The document.
Bank statement, my lord, I can produce before your lordship. I can produce the bank statement,
Please produce the bank.
my lord. I will.
But
That because you have claimed interest till that date.
Yes.
my lord,
So that is necessary.
No,
my lord,
I
if,
will.
if
I
May,
will definitely I will
May
produce.
2016 is taken, my lord, they could have raised out. It has been hit by, even if I say,
When does the question of interest arise?
my lord, we gave the payment beforehand, my lord. In March 2019, we gave the total amount. Whereas we got the possession in August 2019.
That is your case.
Yes, my lord.
So you have covered all the writ petitions in your argument?
My lord, maximum I have been covered, my lord.
Let
And
us
the second,
continue some other day. It's 12:30.
Item number 23, I appear, my lord. Here, my lord, possession was taken after the payment of compensation.
That is the case. That is your
Yes, my lord.
contention in all the cases.
Yes, and
But we'll deal with it.
duly signed by all the parties, even the RNVL, the railway, because
So you mean to say that we'll continue some other day. Construction starts before taking possession. That is your case.
my lord, construction did not start before taking possession, my lord. Possession taken after payment of compensation.
my lord, in regard to the
Lord, I
building,
can-
it
I can
was
show
been
you to your
there.
lordship, my-
Now they crop
Part
up into.
of the project, sir, I'm repeating it n number of times.
My lord, Kavi Subha station.
So to your lordship.
Project did not start, the building started.
But my lord, if I'd say RTI also, RTI, my lord, cannot because of on the basis. I showed out one case, my lord, where entire process of selection in regard to the teachers was being vitiated because under the RTI, the High Court relied upon the RTI. That was not to be taken because until all the facts of the dispute, adjudication, my lord, the
Some other day, I'll read.
You know, there is a signed document by all the parties.
Yes, yes.
That should be relied upon, my lord.
Signed document
Document of yours.
also.
There
Yes,
is a
by
standing
my lord,
document of
my lord,
yours that possession has been
by
handed
the
over.
landowner,
my lord is very
the
clear.
metro,
Is very clear, my
by
lord.
the RVNL, all parties signed, handing over possession, taking over possession, and thereafter, my lord.
One small question, sir. Construction starts before
Now,
possession or
my
after?
lord,
No,
my lord, I will
after,
tell
my
you
lord.
that
After
document.
start,
Kindly
after
have a
taking
look at
possession.
this.
after, my lord.
This- Yes. Kindly have a look at this document. Everything will be clear. This second time.
My lord
RTI
is not regard to this matter. I'm not regard to this matter which is being shown, my lord. In our case, if a specific,
That number has been mentioned.
if a specific case has been mentioned, that is different, my lord. I'm not going to come out with all my entire
10, 11,
cases.
12 and 80.
Please come back with even with the bank statement of,
Yes.
to show the date because you have
Yes,
placed in that.
I will. By
My lord, but,
Supplementary.
yes. I
Here,
will.
my lord, after
I
the
will.
competent authority awarded my lord compensation, then appeal was preferred, and that was weighed in revision, my lord. Ultimately, entire amount paid, then possession was taken. So
That is your
section
case,
80
sir.
will not
Let us see if the
arise here.
documents support your case. We'll
Yes.
deal with it.
My lord,
My lord, I've shown out the entire documents in regard to our case, my lord.
Consider.
Yes.
I've never for once said that I will not consider.
Yes, my lord.
Heard learned counsels for the parties. Paragraph, let the matter appear under the. Shall I grant you liberty, Mr. Pan? You want to come back in supplementary affidavit?
Yes, I will.
Uh,
And well in advance, I will serve them.
Yetar aage korun, heard learned counsels aage korun. On prayer of the petitioners, liberty is granted to use a supplementary affidavit annexing relevant documents. Heard learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on 25th June. All the
Let it be,
matters-
let it be at the fairly at the top because you also hard at length.
Fairly at the top.
Deeply obliged to us.
It's going for a very long time. needs
My lord,
to be-
compensation. My lord, I clearly stated that is not in regard to what they should get out. If they have been claiming, why I have come out with a lengthy portion, my lord, is an amount which is an exchequer, my lord. Railway is a public sector. If they take away the entire amount, is a way which they have been playing altogether a tactics of 21 people.
11, 12.
My lord, a land which was valued 5 lakhs
11
and we have paid 2 crore 50 lakhs for that.
11 to 16.
A meager amount of 2 lakhs they
11 to 16,
bought the land.
and 9
bought
16, same order.
11.
Come with supplementary affidavits in all the matters, Mr. Pan.
Yes, yes, I will. 11 to 16, 19 to 29.
Same order in all these matters.
Yes.
My lord, I am not in 3 matters, my lord. In item number.
I'll call one by one.
Yes, my lord.
Attachment document. Attachment document. আমি এগুলো দেখে নিই, না, না, 12.
My lord, I am on behalf of the 12, my lord.
12 same order.
Yes, my lord.
Same. File দিতে হবে না?
Now,
File দিতে হবে।
13 is my application, my lord. I am for the respondent.
13 same order may be passed.
What same order? You are giving order.
আরে না বাবা অ্যাডজন হচ্ছে
না, adjourn হবে
আশ্চর্য,
না।
আমি কেন ও
না,
তুমি
না।
করবে মামলা করো
না, না, adjournment-এর প্রশ্নটা তো আমাকে জানতে হবে যে why it is at the
আরে উনি আর্গু করেছেন হাফ হয়েছে আবার পরে করবেন
মামলাটা।
আচ্ছা তাহলে তুমি করো এখন
I'm not calling the matters in this.
ইয়েস
My lord, let it,
The metro.
I am for the metro.
In the
It
first, all these matters, I am given to understand that all on similar issues.
Only 3 matters I am not there.
Issue is similar.
Yes. Argument has been commenced by learned counsel for the metro railways.
Yes.
So he is going to.
But the disputes are possibly different. Because the question is that they are asking for interest under section 80.
Yes.
And that interest is only payable to them in the event the possession is taken without making payment.
Same issue.
So that is, issue is same. Issue is same. My lord, the question is, my lord, in my case, I can say, my lord, this, that the possession was taken after the compensation was
That is the
paid.
case of metro railways in all the matters.
No, your lordship asked for one report to be filed, and I filed a report. And secondly, my lord, the back papers, the supporting documents relating to this report, that was asked by your lordship, my lord, during and in course of hearing. So I have filed it.
Today?
No, earlier. And so, my lord, the question is, my lord, I have given the details of the issue in seriatim.
I'll take up the matter one by one.
Yes, that is better, my lord.
Date, I'm fixing it on 25th. On 25th June.
25th June.
Same one.
My lord, one thing which I mentioned, my lord, if my lord, there is a determination of compensation
I'll hear
and
it also.
compensation is deposited with the competent authority, whether it is withdrawn by the landowner, that is depends on him. If the compensation deposited
law
with
says
the
otherwise.
competent authority,
The moment competent
that
authority
is the my lord compliance.
deposited,
That is the compliance of the order.
that is the deposited, then competent should
The
issue me
land
notice.
receipt of
Yes,
compensation or
then only
disbursal of
competent authority can
compensation,
take the possession.
Not depositing compensation.
And they can
Section
be,
80.
my lord, landowner can withdraw after the amount deposited with the competent authority.
We'll
He
go by
can withdraw.
the language of section 80.
My lord, as
No,
The law.
but on the question of section 80, my lord, a coordinate bench of this Honorable High Court has held a different approach to the issue. And I will place the judgment as and when 25th, when the matter, and my learned friend was there in the matters. So where Metro Railway was the petitioner.
Please place the judgment on the next date.
My lord.
Definitely, I'll definitely consider. Yes.
এবার পয়সাটা দেখি।
14.
I'm there, madam.
Same order.
Same, madam. 15 also same, madam.
15, same order.
15, you. Oh, my lord.
Lordship, in item number 15, I am appearing, Lordship.
With the same order.
Yes,
we
yes,
passed?
Lordship.
25th June.
Yes, Lordship. Comments.
Yeah, 15, okay. Egg minute. 16, madam. 15.
16.
My lord, actually, I say, my lord, she should be 16 because the same petitioners are there. Ankit is in the.
I am, my lord,
And I am in 15. She is in 16, my lord.
Yes.
That is 7-8. Read petition is 4879 is mine.
So I'm passing.
And 4880 is her.
Same order is being recorded in
Madam.
both the matters. Yes. What is the next similar application?
My lord, 19. From 19 onwards to 29, my lord.
You are
In which one I am not there. In item number 23, I am not there.
You know, 23 I appear. my lord.
The same order will be passed.
Same
from
order may be
19 to
passed.
29.
My lord, my lord.
19 to 29. Oh, these are analogs.
Now, my lord, your lordship has heard this matter substantially. My lord, let it be heard in part. This is my honest request.
Trying to throw me out of this determination.
No, I'm not.
I'll be back.
Well,
Mental matter.
Oblige, my lord.
Yes. ওই একসাথে রাখতে হবে একসাথে রাখতে দুটো জাজমেন্ট আছে
এই যন্ত্রটাকে দিয়ে দে এগুলো এগুলো দিয়ে দে না দাদা
Yes. Mention matter. After that, I'll go back. There's only one mention matter. I'll go back to the motions after that.
960.
960.
Another statement.
Yes, 960.
My lord, I appear for the petition. My affidavit of service. Yes, ma'am, for the statement. What happened in this case, my lord, the petitioners my lord, applied for mining lease in 2011. My lord, that was approved in 2013, 7th March 2013. At that time, my lord, 2002 rules was my lord, prevalent. Now, the approval, after the approval, now impact assessment, all have been done under 2002 rules. And ultimately, the registered mining lease was, my lord, executed on 2nd May 2019, my lord, as per 2002 rules. Well, that lease was going to expire on 2nd May 2024. Well, there was a provisions was that one should apply for renewal because there was a provisions for 5-year renewal. Only one time initial lease was 5 years and another period is 5 years prior to 6 months of expiry. Well, we duly applied in prescribed manner.
Not considered.
Not considered. Now kindly take Rule 12. Rule 12.
Have the 2002 rules.
The 2002 rules, my lord.
Yes.
Now kindly take Rule 12.
Yes. Rule 12. Yes.
Yes, my lord. That is the exact my lord. These clauses in the lease deed is also similar to this. My lord, Rule 12(6), my lord. Sub-rule 6.
Supplementary affidavit is patla tha.
Yes.
Now, immediately on expiry, the portal has been closed. The 6 months extension till it is considered that we are entitled as per the existing rules. Kindly take on immediately on expiry, because it's now through the portal. We cannot operate without the portal being allowed to operate. Annexure, you will also kindly take is this second page. I'm sorry. Page 4.
Yes.
Page 3, it starts. Page 4, you'll also will getting blocks lease period expires. Now, for this, my lord, kindly take the applications. My lord, it was the lease, my lord, page 1 to 8.
1 to 8.
Yes, application for renewal.
Yes.
Prior to 6 months, that is the my lord, provisions. One has to apply my lord, 6 months prior to expiry of the lease. It was made on 30th October 2023. 2nd May was scheduled to expire. Then the reminder was also given, my lord, page 152.
Yes.
Now the mining operation has come to a standstill because of the closure of the. For these reasons, my lord, I am seeking interim protections, my lord, for the time being. Because these 5 years, my lord, lease clause, my lord, kindly take the lease deed, my lord, page. Yes, my lord, page, it starts from my lord 38. Kindly take my lord, page 39.
Yes.
This term you also will get it from the second paragraph, 5 years. The renewal provisions is page 53. I don't know whether it is legible. Clause 3.
Page 53.
53. Is it legible?
It is. It is.
Yes.
Yes.
Page 53, you'll also find the the mining lease shall be renewable for 1 period, not exceeding 5 years. Then kindly take, my lord, the 3rd paragraph. If the lessee is desirous of taking a renewal of lease, renewed lease of the
premises,
of the premises hereby demised or any parts or part them for any further term from the expirations of the term hereby granted and is otherwise eligible, they shall, prior to the expirations of the last mentioned term given to the state government, 6 calendar months, note, previous notice in writing, and shall pay the rents, rates, royalties hereby reserved, and shall observe, perform all several covenants. Then for the term of 5 years, one time renewal. They are absolutely silent.
Kindly read the proviso term, page 53, proviso, my lord. Provided, however, the state government may refuse to renew a mining lease over the whole or part of the area covered by the original.
Refused.
My lord, they have served one, my lord, supplementary affidavit, whether they have, my lord, filed it or not, I do not know, my lord. Where from it appears, my lord, they have annexed one order. But that has been passed by the. Yes, my lord.
That's relating to, my lord, penalty which you will also.
There is no order.
Yes, my lord, the second supplementary. I'm sorry.
Supplementary.
Right. What a key.
The principal secretary has passed on order, my lord.
That's relating to, my lord, they imposed penalty, my lord, on us, my lord. We came before your lordship set aside it. It was adjudicated upon by ADM. Then there was the provisions of appeal. My lord, we preferred an appeal. Now the appellate authority, we have annexed this to show that they have acted on my lord, 2002 rules. My lord, page 7. My lord, kindly take page 7 of the order of the affidavit, first paragraph. Nothing to do with the renewal. It's absolutely a different matter. My lord, page 7.
ADM?
ADM was, my lord, initially a penalty was imposed without adjudication, without hearing. for shortfall of mining. That was challenged before your lordship, before you set aside and remanded the matter back. Then ADM passed an order. Now the quantification ADM refrained from doing, referred it to the audit branch that it should be quantified. But the ADM did not take into account the force majeure circumstances, etc. Then we preferred an appeal. Now the appellate authority had confirmed the order of the ADM only. And we annexed this only to show page 7.
So this is not with regard to extension.
Not with regard. You also will find it from the first.
Extension has not been refused.
Not been refused.
Renewal, ma. If the renewal is not considered, then the authority will consider. There's a discretion provision is there, madam.
Have you seen rule 2000, the 22?
Well, I have not seen.
Yeah, I'm giving.
12 clause 6.
Whether this has been disposed of or not, I do not have any instruction on that. I have to take whether this renewal application is disposed or not. But that I have to take instruction.
Nothing.
We have to take
Not
instruction.
disposed of.
That instruction. Yes, madam. We have not received any
Let
instruction.
him come back. Immediately upon reopening.
Yes, not disposed of. Your lordship
Please
kindly
give me a
record
copy of this. Not the entire is not required. The relevant provision.
rules.
Rules.
Yes, I'll. Your lordship kindly keep it.
I'll keep this.
Yes. I have got another. I'll get it. Only in the meantime, let them. Otherwise, 6 months will also expire.
No. If they have not, no, come back immediately after vacation. Because if they have disposed it off in the negative.
Not, your lordship
then
kindly
the record
record
is
my
negative.
undertaking not disposed of. Because if they reject it, then need to give us the hearing. No notice, nothing.
You cannot say anything without it.
If they have granted, it is automatic on our prayer. But if they want to reject it, they need to give
Then,
us.
considering the circumstances, come back next week.
Next week.
Before vacation.
Because the laborers who are all now jobless.
Her learned supplementary affidavits submitted by the petitioner are taken on record. Learned counsel for the petitioner submits that the petitioner was granted long-term lease for a period of 5 years. The date of lease dated 2nd May 2019, which was valid till 1st May 2024.
2024.
1st May 2024, comma. In terms of the West Bengal Minor Minerals Rules, comma, 2002. Stop. The petitioner sought renewal of the lease
Rule 12, 6 months.
I'm so sorry, I've lost the page.
Yes, rule 12 is just 4 page. 5 after 4 page.
From the beginning.
From the beginning, after 4 page. Because those are the schedule and annexures.
Yes, renewal. In terms of Rule 12 of the 2002 rules, within the stipulated time frame of
6 months prior to.
6 months prior to expiry of the lease. Stop. The application is yet to be considered. Stop. Learned counsel for the petitioner, paragraph, has taken this court to clause 12 within bracket 6 of the 2002 rules, which envisages that if an application for the renewal of a mining lease submitted to the receiving authority within the time as referred to in subrule 1 bracketed is not disposed of before the date of expiry of the lease, comma, the period of that lease shall be deemed to have been extended for a further period of 6 months or period ending with the date of receipt of orders of the state government thereon, comma, whichever is shorter. Whichever is shorter. Learned Counsel submits that the petitioner is unable to continue with the mining operation in terms of the said provision since the portal has been closed.
What I suggest, University can dispose it of these petitions. If they have not disposed it of my applications, they will do it within certain time. And in the meantime, if they have not disposed it of, they need not to grant extension of 6 months. But if they have not disposed of, then automatically these provisions it can be, because it was filed in April.
Let him come back next week, because if he has disposed it of, it will be a different order. If he has not, you get the time.
Because if he has rejected, I need to challenge it afresh.
Yes.
That I know.
Yes, yes.
Let it come back. I'll give you a short date. Can you come back on 21st May?
Yes.
Next Tuesday.
Yes.
At 12:30.
The Learned Counsel for the petitioner, Learned Counsel for the respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 21st, same heading here, mention matter to 21st May 2024. It will appear as a mentioned matter.
I'm grateful. দুটো সাপ্লিমেন্টারি একটা এফিডেভিট অফ সার্ভিস আছে
Two supplementary affidavit, act of service. Two affidavits of service.
Two affidavits of service, one in respect of the main, another in respect of the supplementary.
Yes, we go back to the motions. Seventeen.
17, my lord, in this matter, I am appearing for the petitioner.
Yes.
17. Reporter will be there, my lord.
Wanted to take further instructions.
I have taken instruction, my lord, that is. The last one, your lordship director has to take instruction for the classification of land regarding, my lord.
Submitted that the enhanced award was paid to the petitioners.
Enhanced amount not paid. Kala amount has been paid at the, in arbitration.
My lord,
Class of land has been enhanced, but their land is was classified as diesel petrol pump. That is that he's not entitled for enhanced amount.
Petrol pump is not a classification.
That is why we have
What is
submitted
the
an application before
This
the.
was in submission on the earlier date also.
Yes, my lord. That is why currently see on page 2 of my report, my lord.
Yes.
This is an application filed before the BLRO by the ADM for correction of record of right. But the classification of land in LR record of right has been mentioned as BT. And the Mantobbo column is diesel petrol pump.
Petrol pump cannot be a classification.
But kindly see, my lord, the RS record of right, my lord. Last time I have
There may be a petrol pump on the plot, but can that be classification?
That is why we have submitted an application for correction, my lord. But from similar RS record of right, it is appearing classification as a diesel petrol pump. The last time RS record of right.
এটা
And the arbitral award was also not communicated to the petitioner. He wanted to give instructions. Give the order dated March 19, 2024.
My lord, I am relying upon the report of the state, my lord. Can you consider how they have said and what is the affidavit filed by the National Highway Authority?
Now they are, my lord,
Ma-
going for execution the award passed by the, my lord.
I'm not execution. There is no question of execution in this award. The arbitrator says variety classes of land, you are entitled to get the same amount. But can you turn to page 7 of the state report?
Now, from RS record of right, it appears that the plot, the classification of plot is diesel petrol pump, my lord.
Right, this is unknown to law. In the classifications, I am aware about Vastu, Pukur, VT, etc. I am not aware about petrol pump.
Page 7, my lord. Can you consider the
Record was
oh, my lord, record of rights? It is a state's document. Can you consider the state?
You get it corrected, but in the meantime, you have to pay the compensation.
And not only that, there is a circular to what extent that they can take. And I'm coming, my lord. Page 7 of the state report.
Today's report.
No, my lord. Previously, they have filed a report on 13th February 2024. We have received on 13th February 2024. My lord, got it.
11 January.
Affirmed on
11 January.
This copy, my lord, if you lordship can this copy, because I have it is Joshua Piti letter.
Nirmal Chandra Ghosh, yes.
I can turn to page 7 of the state report.
Yes. VT.
VT. Now, my lord, what will be the classification should be considered at the time of granting of compensation or adjudication of compensation?
Kindly say again.
Let me
Where is the award copy?
Nothing. Now, my lord, I what have done? My lord, this is my learned friend will not dispute at least this notification. Certain undesirable practice has been come to notice of the central government. This includes change in nature of land or adoption of incorrect classification of land for determination of market value of land. It may be noted that the nature of land has to be taken as recorded in the revenue record on the day of publication of section 3 notification.
Yes, that's the
So
law.
subsequently what they have done, it is immaterial. On the date, this is the VT classes of land and they have to take that as the VT classes of land. Now, my lord, can you consider the next report?
So, Mr. Roy, you are actually challenging the award.
No, award granted VT classes.
Oh, award has granted VT.
Yes, that is, I am coming to that also.
The copy of award has
Yes,
been
my lord,
sent.
that your lordship will find.
They have annexed in the
They annexed.
They have annexed in the requisition.
Yes, because I'm not challenging. I am only asking for the determination which is given by the color arbitrator registered of the
Asking for implementation.
implementation, page 22.
But execution of the award.
Yes,
There is a provision for execution of the.
what is the quantification? What my learned should be. Page 22. My lord, can you turn to page 22?
Page 22. Yeah, this is the award.
Yes.
Yes.
There your lordship will find the body or VT classes of land and house.
Yes.
These are the,
It has been enhanced. Yes.
yes. Now I asked for the other person got the amount. I did not receive any amount, enhanced amount. Because I am not supposed to know what is the amount they have discussed. They have said that this is the amount you are entitled to get. That I have also annexed in my application. This is the amount I received. When others got, I made an application that is a BT classes of land. I am entitled to get higher compensation. On that score, they have said, no, it is recorded as petrol pump in our record, so you are not entitled to get compensation. Now, my lord, this query came up for consideration before this honorable court also. Apart from that, my lord, can you consider how the National Highway Authorities submits the report? Can you consider the report of the National Highway Authority?
Yes.
Paragraph 9. Page 5, paragraph 9. It is pertinent to submit that, in fact, that of the present case, the petitioner has admitted he filed an application for enhancement of compensation as per 3G5. Before the London Arbitration Ministers, pursuant to the same, he had also participated in the arbitration hearing. It is further pertinent to submit that the petitioner in the petition has admitted that his acquired plot is VVT class of land in the record of rights, for which he admits to have been received an even enhanced compensation and hence the petitioner cannot claim compensation for the commercial category.
Not compensation for the commercial category.
So it is the enhanced compensation paid, I have received. This is a specific statement made by the National Highway Authority. On the basis of the what document? Because my lord will not get the document because of the state. That your lordship kindly turn to page 20 of the state report. Serial number, my lord, your lordship, that the tabular.
Page 20.
Page 20. The tabular statement, my lord will find as tabular types.
It is not paginated.
That is this.
Yes.
My lord will find the petitioner name is appearing on serial number 417, left hand column.
Yes.
Before arbitration, my lord, can you consider 307 because it is not done by the arbitrator. It is done by the competent authority.
Yes.
Land value and after arbitration, my lord, next column is after arbitration. Rate, my lord, got it? Same. So what enhanced amount I am entitled to get? 0.
Yes.
So the enhanced amount of nothing to that extent, nothing has been given to me because they have admitted it is a petrol pump. Now, similarly, this question came from constitution before this honorable court also. This is a division bench judgment where the state preferred an appeal. Last paragraph, my lord, because this sort of instruction was caused the honorable single judge, some remarks has been leveled against the person who was issuing this that information. That has been struck off, my lord. I have no objection because I have last paragraph. However, with regard to categorization of the property in question, we are in agreement with the learned single judge as on the face of the record it cannot be disputed. The land in question is Bariviti, and therefore the writ is entitled to compensate the enhanced rate for the category of land as appears from the award dated 18 January 2016. এটা কবেকার awardটা দেখো তো? Passed by arbitrator. According to the parties concerned, right to recalculate the compensation as directed by the learned single judge within 4 weeks from the date. After that, it was directed to be disbursed. The same argument was advanced before the honorable single judge. Now, my lord, if your lordship wants, I can produce or so it is a rough copy of mine, my lord, for the honorable single judge. Judgment, my lord, this is the one copy is with me. If your lordship may allow me and forgive me to hand over this type of copy to your lordship.
The single judge.
Single judges.
Yes.
That your lordship, this is the honorable single judges. The first paragraph, my lord, can you ignore the same because there is aspersion made against the authority. Next, my lord, in the record of rights, it appears at the bottom from the last paragraph. Honors, my lord, can you consider?
First page.
Yes, my lord. Subsequently, well, may I find it out for your lordship, my lord? Extra copy there, my lord. Division হয়েছে দুটো ছিল না? Sorry, my lord, I beg to be corrected, my lord.
Yes. But it's simple matter. I don't know why.
Now what they're doing is what is there for the avoiding, my lord. In their records, it appears is a witty nature of land. Montobbo column, my lord knows better than me. Ask my lord, what is the Montobbo column and 13 column in the record of rights? What is the implication? But predominantly the class will be from the Sreni which is there. It is their document, record of rights itself, it appears, my lord, it is a class of VT classes of land. Then how I am not entitled to get any compensation on VT classes of land? I'm not challenging nothing. The arbitrator says, yes, VT classes of land is entitled to this much of compensation. Then also I'm not getting the same. And the arbitrator did not say that you are not entitled to get. Arbitrator says this classes of land will get this much of amount. It is the competent authority who will adjudicate. And this was done earlier on occasion. And argument was advanced to that effect. My lord, it was up to division bench, my lord, it was held that no. The classes of land as recorded in the record of rights at the time of issuance of the notification are entitled to get this amount. These are my submission before your lordship, my lord. And so far.
Anything to add?
My case is very simple. From the RS record of right, it appears the classification of land is diesel petrol pump. It appears from the RS record of right.
Please come to the writ petition. The RS record is in your report, I think.
No, that is LR.
LR record of right.
At the time of
The mistake
publication of the LR was there. Because LR was there 1976.
It has been recorded as BT matter. It is true matter. But prior to that,
Petrol pump cannot be a classification, you admit.
but my
Can
status,
petrol pump be a classification of land?
we have submitted
There
application
may
for
be a palace, there may be a auditorium. That can. So when there's an auditorium on a land, you say classification is auditorium.
is appearing
Can
from the
that be
record
the
that
class of land?
Used for the purpose, which purpose it is used, that can be derived from the record of rights. It is petrol, it is commercially. If that is some higher, all the time entitled to get
That is the
much
user.
more higher.
The user. And the
On-
National Highways Authority has recorded that he cannot claim a commercial user. He's not claiming.
My lord, if your lordship, lordship kindly come their prayer portion, lordship. His prayer, lordship, always
This guy has gone
reassessment.
back to the technical.
No, my lord, it is not a question of technical, my lord. Every time, my lord, my learned friend always making this type of submissions. His prayer is lordship reassessment. My lord, to reassess.
Now, my lord, the person who have affirmed this affidavit under the National Highway Act, he should come.
Mr. Roy, reassessment of the arbitral award because it has not been granted in terms of the arbitral.
My lord, reassessment, the compensation amount payable to the petitioner in respect of his plot of land acquired under LA case number such and such.
Absolutely. Yes, it's correct. It has
On the
to be
basis
a-
of the records of the record of rights.
Where, Mr. Roy? The court is
Yes, sir.
speaking for you. Why are you?
No, my lord, something is there every time, my lord, it is something.
Well, my lord, kindly see the prayer, my lord. His prayer is totally reflected in a different way, my lord.
The prayer says reassessment of the compensation amount.
Yes,
It is
ma'am.
absolutely correct. You have to reassess the compensation amount in terms of the arbitral award.
My lord, in terms of the arbitral award, where my lord, as per my learned friend said, as per the record of rights, my lord, they give the, though I am not in that position, well, because I am not the
So you
disbursing
also
authority.
agree that petrol pump is a class of land?
No, my lord, I am not that. Because actually the commercial portion is mentioned in the class of land. If that is the petrol pump comes on that portion,
That
the
is
commercial.
ignorable.
Well, only this, my lord, because VT.
And he is not claiming.
I am not
commercial.
claiming.
If he claims commercial, it is much higher.
Well, because as per
Not
the
claiming
as per the class of land can be classified in a different ways.
Your report also says it is VT.
Yes, my lord.
So there is no dispute with regard to that.
Lordship, because I am not only lordship, amount has already been deposited, lordship. Because lordship, my prayer is regarding their pleadings.
Admitted position, it has been recorded as VT.
between LR record of right, not
Yes.
any RS record of right.
When was the
The notification issued,
done?
my lord.
When was the notification done? The LR record was prevailing at that time? Yes. So it is settled law. that
RS
it has to be
56,
taken into consideration.
LR starts from the, my lord, subsequent to that. It is.
So let me dispose it off.
Only one record of submission or submission can be recorded.
From submission that it is, it will only prove your ignorance, nothing else.
My lord, if it's petrol pump, my lord, the matter is over, my lord. I'm entitled to not only the VT rate, I'm entitled to the commercial rate.
Yes.
That is much higher than what I am claiming.
The-
If my learned is admitting that, then my lord, this.
Yeah, I thought so. That you are claiming the commercial rate and they have said you are not entitled. You are not actually claiming the commercial rate.
I only record in my
The
record of
NHI
rights.
says so.
Yes, I am.
You are not entitled to the commercial category.
That goes. In one hand, you are saying that petrol pumps, you are not entitled to get commercial rate. In the other hand, is the VT classes of land. This is
Hard learned counsels for the parties. Instruction with it on article judgment. Yet a report submitted on behalf of the state respondents is taken on record. Third learned counsels for the parties. Paragraph. The primary grievance of the petitioner is that though in the award declared by the arbitrator under section 3G5 of the National Highways Act, 1956. Compensation with regard to ET class of land was enhanced by the arbitrator, the enhanced compensation was not granted to the petitioner by the state respondents in assessing the amount payable to the petitioner solely on the ground that the plot in question is a petrol pump and not a BT. Learned Counsel for the state respondents submits that since the plot has been recorded as a petrol pump in the RS record of rights, the petitioner is not entitled to the enhanced award granted for BT class of land. Paragraph. Learned Counsel for the National Highways Authority of India takes this court to the prayer made by the petitioner in the writ application and submits that the prayer for reassessment of compensation amount payable to the petitioner cannot be granted after an award under section 3G5 has been declared. Yes, that is your submission, madam.
My lord.
One more submission, the award has been filed in there 2015 and they have come and first represent survey 2020, after 5 years. The page 24 of the repetition.
When did you serve the copy of award, which is mandatory? It's not served at all. Any official record? Petition starts from receipt of copy of award, isn't it? Paragraph. It appears from the report in the form of affidavit. Where is the LR records?
That is page 7 of the report of the state.
It appears from the report in the form of affidavit submitted on behalf of the state respondents that the plot in question has been recorded as BT in the LR record of rights, which was prevailing at the time of publication of the notification
Under section 3A.
under section 3 capital A of the West Bengal Highways Act, National Highways Act, 1956.
May I hand over the portion where it is?
Strangely, the plot has been recorded as petrol pump in the RS record of rights, and it appears from a letter issued by the additional district magistrate within bracket land acquisition bracket closed, Nodia, to the block land and land reforms officer, Krishnanagar -Roman 2 on 22nd March 2024 that the block land and land reforms officer has been requested to correct the classification of the plot in question, meaning thereby, that the state admits the plot to be classified as BT. Paragraph. it is not in dispute that the enhanced compensation in terms of the arbitral award for VT class of land was not granted to the petitioner. Stop. In view of the fact that the plot in question is VT and the arbitrator has enhanced compensation for VT class of land in the award under section 3G5 of the Act of 1956, the petitioner is entitled to the enhanced compensation in terms of the award for the plot in question recorded as VT. Paragraph. In view of the above, the writ petition is allowed in terms of prayer capital A. Paragraph. Who will do the necessary assessment?
As well as the competent authority under the
Yes, respondent number.
respondent number, my lord. Respondent number 3, additional distribution being the competent authority under 3. Will you assess the
third respondent is directed to assess the enhanced compensation payable to the petitioner in terms of the award under section 3G5 of the Act of 1956, dated 14th October 2015,
14th October,
and disburse the same in favor of the petitioner within 4 weeks.
As your lordship, that
6 weeks. Within 6 weeks from the date, or let it be 2 months because it has to be assessed.
As
Within,
your lordship, 2 months
from the date of communication of this order.
2 months, or if they want, my lord.
Disposed of.
My lord, only one more thing, lordship. Lordship, kindly come to lordship, page 5 of this writ petition, my lord. Only for my satisfaction, my lord.
Page 5, yes.
My lord, para 8, my lord. Well, it is the pleadings of this petitioner. The states that in the arbitration proceedings, the nature of the land was considered, that is Bari, Viti, Dokan, Ayush, Hamon at the rate of rupees such and such per acre. But no decision was taken in respect of compensation amount of commercial plots.
How is it relevant?
No, on the basis of this, lordship, my report has been prepared because my submission is, lordship, they had been admitted that the VT amount of compensation they had been received. Sir,
They have not received.
no, well, this is as per our instruction on the basis of the report has been
That was
prepared.
the instruction how the
because
National High Authority
yes,
submitted this
in
instruction.
respect of the compensation amount of commercial plots, my lord.
They are not claiming that.
Yes, my lord. But lordship, they are admitted, lordship, they have received the this land was considered, that is Bari, Viti, Dokan, Ayush on the basis.
Where is it admitted that they have received?
My lord, that is lordship, they had not been mentioned.
This is the document of the state where it says that they have not received.
But lordship, that
It
is
has
not
not
been
been given at
reflected
all.
in these paragraphs. Only lordship, that is my.
Where is it said that?
Yes,
they
my
have
lord. Can you
received?
turn to paragraph 8?
Yes, my lord.
Considered
They
by
said, my lord, the land was considered at such and such, but no decision, lordship. From this, it means, lordship, they have taken the decision on the basis of Bari.
That. I'm sorry, with
My
the,
lord,
My lord, the award has been interpreted.
my lord, this is their
I'm really sorry.
pleadings.
With the very little English that I understand, this doesn't mean that.
Well, but no decision was taken, my lord. That means, my lord, decision was taken in case of Bari Viti.
Arbitrator took a decision with regard to Bari, Viti, Dokan, Ayush, but did not take any decision with regard to commercial plots. Does that really mean that the petitioner received them?
No, my lord. No, my lord. I'm not on that, my
The
lord. But
arbitrator
this is
did
their
not take a decision.
pleadings. It is their pleadings. It is reflected, my lord, in this way, my lord. Only on the basis of this, my lord, my report has been prepared.
Did not take a decision on commercial plots?
No, my lord. I'm not on that. I am not on that, my lord. From this, my lord, never it is reflected that the petitioner received the amount.
Not
No, I am not that on that.
At the moment, it is not relevant at all.
Careful, dear
You can
lordship.
take this back. You can take back the judgments because it's the law.
My lord, only one more indulgence, my lord.
Everything
Only
they said that this is the thing which is modification of the arbitral award. Yet,
you submitted, is it? You can
yes, yes.
My lord, one more indulgence, my lord. The entire compensation, including the enhancement amount of compensation, has already been deposited before the competent authority, my lord. But if your lordship kindly record it. please.
NHA এর একটা submission record করুন। NHA এর ওটাতে add করুন। The entire compensation amount has been deposited before the competent
Including the
authority.
enhancement amount. my lord.
The entire enhanced compensation amount has been deposited before the competent authority by the NHA, National Highways Authority.
No.
Yes, call the list.
961.
Yes, my lord.
My lord, I am the petitioner. My learned senior is on VC, my lord.
Yes.
Mr. Sankonath Mukherjee is VC, my lord. Yes.
My lord, kindly fix it after vacation then.
For the state?
Yes, my lord, I am appealing for the state. Devashish Das. Yes, because my lord, they are, yes, my lord, because of the election, my lord, I have already communicated, my lord, to the concerned authority, but they have yet to supply me all the information.
Time, Mr. Mukherjee. Not audible. Please unmute. Please unmute.
Just keep them.
I'm granting an adjournment to the state is not ready with the document.
Yes, well, a record cannot be produced before vacation,
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 19 June.
If you bless, my lord.
Please be ready with the documents on the next
Yes,
day.
my lord, on the next date, my lord, I will repeat it.
962.
Shaya for the writ petitioner. My lord, will remember, Worship, this matter, my lord, I have already concluded my submission and I have relied upon few authorities as because maintainability of the writ application was challenged. Now, my lord, if Lordship allows me to refresh for a brief recapitulation of the facts. My lord, the petitioner is a registered leaseholder with the railways and in that capacity has participated in a tender. On being adjudicated as the highest bidder, he executed an agreement with the railways for transportation of consignment in a parcel space in connection with one train. It starts from Shalimar and departs at Mumbai. My lord, thereafter, my lord, upon carrying on with the operation of the leasemate operation for a few months, petitioner faced some inconveniences. Inconveniences in form that petition under the policy, there is a provision for placement of rakes at the appropriate time. But those were not placed. For that, consignments could not be loaded upon. And secondly, my lord, there was a change in the terminal. After execution of the agreement, there was sudden change in the terminal. And for that reason, my lord, there is also a provision that for such sudden change, there has to be an intimation and willingness needs to be obtained from the operator. But that was not obtained. Now, thereafter, my lord, petitioner made correspondences with the railways, asking them to resolve this issue. But despite acknowledging the same, and the railways also assured that the problem will be sorted out, they did not come with any lordship solution. My lord, thereafter, my lord, petitioner was constrained to suspend the operation. My lord, kindly note this word suspension. Suspend the operation, my lord, and thereafter, without resolving, even after acknowledging the issue, the railways terminated the lease agreement without any notice. Challenging that, my lord, I have preferred this writ application. Lordship has heard me at length and has granted me protection from liquidation of the security deposit, which is still lying with them. Now, my lord, my learned friend appeared and also placed his case and said that the writ petition is not maintainable because there are alternative remedies in the form of departmental appeal and the arbitration clauses are there. But my lord, I have, to that extent, my lord, I have relied upon few authorities. Lordship probably have those copies with them. And thereafter, my lord, I have placed my case in merits. And today I will be relying upon another 3 judgments. Two of these coordinate bench, my lord, has passed this order. And one by the recent judgment of the Honorable Division Bench, presided over by Justice Tandon. Lordships, their lordships were of the opinion that, my lord, in respect of contractual matters also, the writ court can entertain. And also as a consequential relief, my lord can even entertain writ application for monetary claims. So, as because they have terminated my lease without there being any prior notice. Now, my lord, and after that they have must have floated a tender and they must have given it to a third party. So only thing which is at present required, my lord, my security deposits are there.
They have given it to a third party.
Probably, my lord, because I have left it long back. I have left it 1 year back. So probably they must have floated a tender and someone must be operating then. So in that capacity, my lord, only to the extent of refunding of the security deposits, my lord, I will be relying upon the division bench judgment, which I have just, lordship, obtained. I have also appeared in that matter. Learned additional solicitor general has also appeared. And I'm giving one copy, my lord. For that.
Yes.
Yes, my lord. Without taking lordship's further time, the operative portion at page 14. Prior to that, my lord, the judgment upon which this reliance has been placed has been quoted. And here also, my lord, upon deciding on several issues, the operative portion says at page 14 that taking a clue from the aforesaid decision of the Supreme Court, there is no fetter on the part of the writ court to entertain the writ petition, even if it relates to a monetary claim. As the exercise of such jurisdiction is discretionary, the relief in this writ petition is composite one, and if the monetary claim is intertwined and or consequential to the main relief, the court is not denuded of its power to render complete justice, and such discretionary exercise is based upon a sound principle. We thus do not find that the order of the single bench deserves any interference. Lordship, Railways appeal was dismissed. Now, my lord, Lordship has also passed several orders that if the termination notice is without any reason, my lord, Lordship, then Lordship has directed the railways to refund the security deposits. Lordship's order is there. My lord, I am. একটাই কপি আছে আমি তোমাকে দিয়ে আমাকে ওই নাম্বারটা দিয়ে দাও 255 WPA 25566 of 2023 5566 of 2023 ঠিক আছে Shiva Prakash. The operative portion, my lord, page 3, internal page 3, all of you sees.
Yes.
In the case in hand, the petitioner served several notices upon the authority, stating reasons for which he was facing difficulty to operate the contract, and finally intimated the authority by a letter issued on 30th December 2022 that he was constrained to stop operation due to such difficulties. There also, my lord, some operational inconveniences were represented. Therefore, it cannot be said that the petitioner violated clause 8.4 of the lease agreement in any manner. My lord, thereafter, also clause 25.1 of the agreement deals with the right of the leaseholder to terminate the agreement after serving 60 days notice to the railway administration. The clause lays down certain conditions to be fulfilled by the petitioner prior to such termination. In the present case, the petitioner has not sought to terminate the contract. I have not sought any termination, my lord. I have only sought suspension and has only requested the assistance of the authority so that he is able to operate the contract smoothly and effectively without incurring any loss. The letter issued by the petitioner does not express intent of the petitioner to terminate the contract. Therefore, clause 25.1 is also not applicable in case of the petitioner. No other reason has been assigned by the authority in terminating the contract of the petitioner. My lord, kindly skip over to the next page at the last paragraph. It is not in dispute because what the penalty has been imposed is the forfeiture of the security deposits. My lord, but here, along with forfeiture, there was a blacklisting also. But blacklisting is not in my case. So, my lord, in page 4, last paragraph, it is not in dispute that upon termination of the contract, the petitioner fresh contract has been granted in favor of a third person who is operating in the same route. Since the contract of the petitioner was terminated without any valid reason, the security deposits forfeited and the petitioner blacklisted arbitrarily and illegally, the letter of impugned dated 12th January 2023 is required to be set aside. And accordingly, the letter of impugned dated 12th January 2023 set aside. The concerned authority, being the fifth respondent, is directed to refund the security deposit of the petitioner to the tune of 35 lakhs along with the bank interest thereon, to be calculated from the date of issuance of the termination letter till the payment of the same in favor of the petitioner within 2 weeks from the date of communication of this order. My lord, I am relying upon this judgment because the termination letter which they have issued, my lord, it was not preceded with any notice. I have only sought assistance. They have acknowledged it. They have assured that it will be resolved. But without any intimation, my lord, without any intimation, my lord, they have terminated. And in the termination letter, my lord, the clauses which they have relied upon, my respectful submission will be As you kindly see the letter of termination, which is at page 138. Yes. The clauses is that when I am reading from the middle portion. Yes, para 19, payment of lump sum freight and rent license by the contractor. They have relied upon 19.1. Lump sum freight rent license fees along with GST cess as applicable shall be paid online through REPS contractor amount of the time allowed by the depositing the lump sum freight license amount by the contractor as below. My lord, if the contractor, termination letter, if the contractor for the contracts for the leasing of parcel space fails to pay the lump sum freight for 3 continuous days, he will not be permitted to load in the parcel space till all the pending dues are cleared. And the railway shall have the right to utilize the parcel space as its per own requirement. My lord, it speaks for that I have operated the parcel space for 3 days, but I have not paid them. It is not that this case. I have suspended the operation. I have not utilized the parcel space after suspension. So this clause is not applicable. The contractor shall, however, be required to deposit the lump sum freight for all the days, even if the space had been used fully or partially by the railway on some of the days for which the contractor was not permitted to load on account of non-payment of 3 continuous days. And 19.2, if the contractor fails to pay the full due amount as specified in para 19, even after expiry of the grace period with penalty of such and such day on the delayed amount, the contract shall be terminated and earnest money security deposit shall be forfeited without any further notice, my lord. I have not utilized the parcel space. So there is no question of, my lord, giving the payment to the railways.
You have issued notices to the.
Yeah, I have issued and they have acknowledged, my lord. Kindly come to page 129. 126, my lord.
Yes. This is the communication
This
process.
is the internal communication, my lord. A copy was given to me. The last paragraph, it says that hence it is hereby requested to look into the matter as well as investigate the issue. Complaint pertains to operating also. If any such delay has been occurred due to operational reasons and within the divisional control, then the same may be tried to be resolved at the earliest. So they have acknowledged it. So apparently there is no breach on my part. That they have the right to terminate it or as a punitive measure. They have a right of terminating the punitive measure, but when there is no breach, then there is a clause, my lord. May I kindly come to page 93. Yes. Clause 28.2, my lord. Page 93. By the railway administration, railway shall have the right to terminate the contract for any reason whatsoever after serving 30 days of notice to the leaseholder. And also, my lord, in case of extreme operational exchanges, railway may terminate the contract with immediate without any financial repercussion on either side, with the approval of DRM and concerned PHOD and CHOD. Now, if I had breached or they have punished me for any reason, this is punitive in nature, my lord, then they may not serve any prior notice. But there is no breach on my part.
Yes.
My lord, this has been followed in another clause, 17.2, which is at page 103. Clause 17.2, my lord, page 103. This is a freight marketing circular 11 of 2022. By the railway, 17.2 says that railway shall have the right to terminate the contract agreement without any financial repercussion on either side for any reason whatsoever after serving 1 month's notice to the contractor. And also the railway shall also reserve the right to terminate the contract with immediate effect without any financial repercussion on either side in case of operational exigencies or in case where the assets for which the contract was awarded is not available, for commercial exploitation due to some other development or change in site, or any other reason, full EMD, SD or lump sum freight rent license fee paid by the contractor shall be refunded to the contractor without any interest. So, my lord, my problem was there. They have acknowledged it. Now, without resolving the same, they have also terminated me. There is no breach on my part. And the clauses which they have relied upon has no manner of application in my case. Now, my lord, judgment of the. In another matter, my lord, Lordship has passed an order where Lordship is pleased to set aside the order of termination, which is at page 9. Page 6, my lord, paragraph 9. Page 6, paragraph 9. Also, my lord, here also my lord has stated that also the petitioner was deprived of an opportunity of hearing by the authority prior to issuance of the termination notice, which is in violation of natural justice. Petitioner ought to have been given an opportunity to place his contention before the authority prior to issuance of the punitive measures. Threefold penalty of termination of service, imposition of fine and blacklisting on the petitioner were imposed without taking into consideration and reply submitted by the petitioner before the authority or affording fair hearing to him. But you have held it. The termination was set aside because I was not given an opportunity, and the policy says that notice has to be served prior to termination.
That's all.
And my lord, so far the alternative remedies are concerned, my lord, judgments I have placed on 3 contingencies: violation of natural justice, fundamental rights. Here, my lord, there is a violation of natural justice. I indicated that. Well,
Yes.
My lord, as far as the judgments which have been cited by my learned friend today, I did not have an opportunity of going through them. So, my lord, if that at all is required, my lord, then, my lord, I will. But, my lord, as far as facts are concerned, my lord, and the other judgments are concerned, my lord. Now, my lord, here, keeping the maintainability point very much open. Here, my lord, because there has been orders passed by my lords directing in such cases where there is an alternative remedy of contractual things. It is not about the tender, my lord. There is a contract, and knowing fully well the contents, terms, and conditions of the contract they have entered. Now, my lord, we'll have to kindly understand that these are contractual matters where even the government is one of the agencies. It is just that particular aspect where Article 14 comes into play, where we being a welfare state and a government organization is supposed to act in all fairness. That is the only difference. Otherwise, in the commercial world, we are competing with any other commercial organization, be it railway is competing with other freight people like, well, by shippers or airfare, whatever it is now. So under these circumstances, my first contention is that as far as Article 14 is concerned, when contract is concerned, where a person is a party to the contract, knowing fully well that what are the nuances of the contract, he or she is not in a position to turn back and challenge the terms, saying that they are lopsided, one-sided, and I was not given hearing, and there was fundamental rights and other things have been violated. There has been arbitrariness. Now, my lord, I will take first, my lord, to the facts. Now, my lord, will kindly come to the petition itself. The sole contention of the petitioner before your lordship is that is at page 4, paragraph 4. He starts. He entered into a contract on 7/12/2022. That is at paragraph 4. And there was a valid agreement entered on the 25th of December 2024. So there was a valid agreement which was signed by him, knowing all the understanding.
Ended on 25th December.
It was validly, what I'm trying to impress, it will end with that is a signature. He's a signatory to a particular agreement which is in force, which embodied all these clauses. Termination, he has to go on with the work in a manner which is prescribed therein. Now, he, pursuant to that, he gave a security deposit of 7,94,433. That has been pleaded. Now, that agreement is at page 32. Now, will kindly come to page 32 once. Yeah, my lord. Page 32, Lordship says. My lord, the contract starts on the very top, my lord, on 26th of December 2022. Now, my lord, the wagon was from Howrah to Chhatrapati Shivaji, Mumbai terminus. weekly allotment. Now, my lord, the next page, page 33. My lord, two particular guidelines or circulars were guiding this contract at page 33. One is the marketing circular 11 of 2022 and marketing circular 12 of 2022. One is at page 83, another is at page 106. So, my lord, the first annexure, that is P2, the circular 6 of 2014 is not applicable. So, therefore, whatever submission have been made by my learned friend in connection with this particular writ petition, which is dealing with this circular, there is no relevance of this circular. Now, my lord, so we have to take circular 83 and 106 at page 83 and 106 as far as the terms and conditions are concerned. Now, my lord, I come to factual matrix once again. Now, my lord, will kindly come. See. So, this was first. Now, my lord, he says that, my lord, at paragraph 6, he says that he has perishable goods, and therefore time is an essence as far as his business is concerned. But as far as we are concerned, the contract is concerned, it does not discriminate with regard to the goods which you are going to book on the racks, because it can be anything under the sun, and we have been very, very clear about it. So, you know, that cannot make him steal a march on other people. That cannot be a reason. Then, Miller, comes the main part of it, Miller, which is paragraph 8. The operational inconveniences, which has been categorized in paragraph 8 and its subparagraphs. Now, what are these, Miller? First is that the trains are running late by 8 to 10 hours. Then, Miller, the late B. Then, Miller, there is overall delay of 24 hours in putting the petitioner's sensitive cargo at serious risk of contamination. Then, Miller, D. Petitioner has requested time and again for proper placement of rakes of originating and destination stations for better transit time, which is not answered. In the process, the petitioner has lost a lot of sensitive cargo clients, as it is not in a position to provide better transit time. Upon arrival of train, concerned at LVP are being placed 15 hours after the yard for upholding such perishable items which are getting damaged, for unnecessary delay in placing the rakes by the railways. Then, and due to sudden change of loading points to Wadi Bandar recently from CSTM, your petitioner has lost all the customers and traders, and such change in terminal has been given effect to in contravention with clause so and so of circular 12 of 20, as no prior intimation nor willingness has been given. Now, Millet, this is the main reason why he is said. Now, he has said that these issues were not resolved by the railways, though he verbally informed us. That is, he has stated in paragraph.
Even in writing.
No, Miller, I'm coming to that. Miller, what he has given in writing and what he is saying, Miller, that is what I'm saying, and what we had answered. Now, Miller, it is stated that relevant clauses of the said policies and the Act seek temporary suspensions of the operation of prejudice, so and so. Now he comes to, Miller, the main letter, that is at paragraph 11. What he says, Miller? Page 7. It is stated in no uncertain terms that placement delays of rakes and unilateral change of loading point by the railways is causing serious repercussion in generating cargo traffic, which your writ petitioner is sustaining huge pecuniary loss every day. As such, your petitioner wide letter dated 25/5/2023 made in representation before the appropriate authority to address the grievances of the operational inconveniences within stipulated period as prescribed therein, failing which your petitioner will have no option but to suspend and discontinue the lease operation temporarily till the issues are finally resolved. Now, Miller, so he did not say that I am going to stop it. He said that if it is not resolved, I am going to. Now, Miller will kindly come to page 120, the letter itself.
(128).
120, annexure P3, Miller.
Yes.
Lordship has got it. May I read, Miller? With reference to above most humbly, I hereby placing grounds of non-operation of my subject so and so for your kind information. Railway administration is torturing me with effect from 30/12/2022 for extortion money. A placement of leased so and so, unloading details attached, and this can be certified with placements register available on CPS office SHM. I am continually getting threatening by NN Sarkar CYM and high officials of commercial department of your division for extortion money. Due to late placement, I face abuse of traders and got heavy loss. Now, in this condition, I am not in a position to tolerate threatening of railway officials and traders. On date 21/5/2023, administration has sudden changed the loading point Vadivar to platform without giving any genuine notice. Results to detailed manifest submitted containing leased parcel PKG and weighing party loaded. In this condition, I am not able to operate such leased so-and-so with effect from 25/5/2023. Therefore, I request you to kindly consider the above grounds and arrange to release the refund my security deposit amount of so-and-so. So, my lord, he said this is what the only point which has been mentioned here is Vadibar is the only cogent point which has been mentioned. He has not, in the full letter what I have read, my understanding, all other points which have been specifically mentioned in paragraph 8 and its subparagraph, apart from F, no specific allegations have been made. And he categorically, in unequivocal statement, said that he is not going to load it. And then he, in the same breath, says that you return me my deposit. That means he has no intention to continue. If my lord reads it. Therefore, I request you to kindly consider the above grounds and arrange to release the refund my security. He is not wanting that he is not wanting to operate any further. And here he has come that my termination is illegal, where at the very outset, he had no intention of carrying on. So, in my respectful submission, the writ petition, the whole contention of the writ petition of paragraph 8 is not rightly placed as far as this letter is concerned. Now, my lord, what we did. My lord will kindly see page 122A. This is what has been vociferously argued by my learned friend, that there was an acceptance on our part that yes, we are on the wrong. And we have been guilty of non-performance of our part of the contract, which has been the basis of the problems which have been created by the... My lord,
That's not the submission, perhaps.
my lord, I stand corrected, my lord, if I'm not... My lord, but then there was an acknowledgement, if I'm not mistaken.
There's an acknowledgement.
I stand corrected, my lord. I stand corrected. I stand corrected. But my lord, what we said over here, there's another point which I would like, another issue which I would like to join with my learned friend, my lord. My lord will kindly come to 122.8, my lord.
120?
122A. Lordship has got it. Yes. Now, my lord will kindly see. We said, my lord, in the second paragraph, all your issues are by forwarded to concerned department division for further disposal. Any reply from their end will be communicated to you accordingly. So we said that we are considering. We did not say that we have accepted whatever you have said as sacrosanct. Then we said, further, it is also clarified that supply of parcel van had not been discontinued from both ends till date, other than operational exigencies. Hence, is hereby requested not to discontinue your lease operation when guaranteed supply of parcel is assured from both the railways, because such sudden discontinuation of parcel van from 26/5/2023, which you have mentioned in your letter, will be treated as breach of contract as per para 19.1 and 19.2 of FMC 11/2022. In view of the above, it is once again requested to continue your lease contract, because there is no such ground to discontinue the lease contract when guaranteed supply of lease van is assured as per above provisions, such sudden discontinuation leasing operation will be treated as breach of contract. Therefore, tender will be terminated by forfeiting the security. So, my lord, there is no question of vade alteram partem. When you, in unequivocal terms, say that I am not going to operate from 26th, that's it. And then you say you return my security deposit. And then when we, in answer to that, say that this will not be allowed, we are looking into your grievances, please continue. And if you don't continue, then clauses under 19.1 and 19.2 will follow, and you will be, and your security deposit will be forfeited, and your terms and your contract will be terminated. So, in my respectful submission, this is not a case where he can come and say that he was not given an opportunity. We had made it very clear right from the very outset when he gave us the first letter that, look here, we are looking into your grievances and it will be resolved, which actually our rules provide and circulars provide. Now, in my respectful submission, so the first point, as far as maintainability is concerned and arbitration is concerned, it is hit by this particular letter of mine.
Did you afford him an opportunity of hearing?
My lord, in my respectful submission, now I come to the second point, my lord. Now, my lord, first of all, my lord, a person, my lord, first of all, if he says, my lord, if he would have continued, we would have given, now, my lord, because 19, now I come to my first submission. My first submission is when a person enters into a contract, it is within his knowledge, and I have decisions, the Honorable Supreme Court, my lord, knows, my lord, that if he has the knowledge of the terms of the contract, and when he is put to notice about that look here, these are the terms of the contract, and that will be followed. If he does not want an opportunity and he just commits that particular nuisance, or that particular term is violated, then, my lord, we are within our rights. If knowingly I commit some breach, if knowingly I commit some breach as a matter that I will commit it, even on being put to notice, no hearing is required, further hearing is required. This is my respectful submission, Because now, my lord, I will take, my lord, to 19, the clause itself. If now, my lord, kindly comes. If my lord kindly comes first to the contract. I start with page 90. Where, my lord,
Page 90.
Lordship has got it. My lord, 19.1. Type of contract, my lord, that particular table. Leasing of parcel space daily. Per trip means it has to be loaded daily. Time of depositing at least 1 day prior to the day of start of train. He has to load it daily and he has to deposit it 1 day prior. Grace period with penalty of 0.5 of the delayed amount per day, maximum 7 days. Now, my lord, the same thing follows, my lord. This is daily is with us, my lord. Now, my lord,
bound to pay even without using the parcel?
yes, my lord. Yes, my lord. That is the terms. Therefore, my lord, we said, I'm coming to that, my lord. Now, my lord, we'll kindly come to next. Just the lines, my lord, because what is happening is, my lord, our railway, my lord, will kindly understand our whole perception. This contract of parcel van is that each and every railway, each and every train which is commuting from one particular station to another has a provision of these parcel vans. Now, we open in the tender specifically that this parcel vans will be attached to the commuting trains on day-to-day basis. Now, my lord, whoever has that particular business who can use these parcel vans on day-to-day basis, on payment of an advance amount of money, he should only come. And on understanding of that, they have hired it. That is what the contract was. Now, my lord, if you, and he has not said in even one statement, my lord, that he was not required to load the parcel vans on each and every day basis, my lord. I will come to that contract, my lord. And therefore, he said, my lord, in his letter that he is not going to load it because he wanted to excuse from this day-to-day work because he was saying that it is getting delayed, so more and so forth. Now, my lord, may I read, my lord? If the contractor for the contract for leasing the, I'm just reading under the table, my lord. If the contractor for the contract of leasing the parcel fails to pay the lump sum freight for 3 continuous days, he will be permitted. Now, my lord, he may be permitted to load in the parcel space.
Not be permitted.
He will not be permitted to load in the parcel space till all pending dues are cleared. And the railway shall have the right to utilize parcel space as per its own requirement. The contractor shall hand over, be required, deposit the lump sum freight for all the days, even if the space has been used fully or partially by the railways on some of the days for which the contractor was not permitted to load. That means, my lord, he has to pay for all the days. Now, my lord, if my lord kindly comes, my lord, will allotted weekdays, my lord, if my lord comes to page 32, from here one train takes to reach page 32, my lord.
32, yes.
Yes, lord. Allotted weekdays, my lord, will kindly see it is slightly, my lord, the traveling is such, my lord, that every day, means travel time from Bombay to Kolkata, and Kolkata is it's 2 days it takes, my lord. So, my lord, will kindly see the allotted days, my lord, will show that it is the days there also, here also. That comes, my lord, every day the loading has to take place. Now, my lord, will kindly again come back to the contract itself. Now, my lord, then, my lord, 19.2 of page 90, my lord. If the contractor fails to pay the full due amount as specified in 19.1, even after expiry of grace period with penalty of 0.5 per day on the delayed amount, the contract shall be terminated and the earnest money security deposit shall be forfeited without any further notice. This is what I'm saying. Then, my lord, 20.2, the same page.
Yes.
Leasing of parcel vans should be done on round-trip basis by owing railways of the train on end-to-end basis. That means every day they have to load, my lord, because the train comes on everyday basis. Now, my lord, if my lord kindly comes to the next page, my lord.
Yes.
20.4, my lord, at page 91. If I am allowed to read last but 3 lines of that particular clause. The loading stations may change during the duration of contract based on the changes in stoppage time of trains. Here we did not do, and even the Wadi Bandar is actually a particular yard which is adjacent to the Chhatrapati Shivaji terminus. My lord, it is not that, because my lord will kindly see these racks, my lord, if we allow them on the normal platforms where commutation is going on, it will become very difficult. And it is even stated over here that we have to place these particular racks or parcel vans at a place which is very near to the road, where trucks can come, so that loading, unloading becomes easier. So everywhere we have, my lord, here we use Shalimar. That is Calcutta terminus, because their loading, unloading is much easier than Howrah terminus. Because now new Howrah terminus is easier by road, commuting by road, my lord. But as far as old is concerned, my lord, there is no concept of unloading there, my lord. So now how we will do it? So, my lord, and that Wadi Bandar is only at it's an adjacent. So that is not that particular place we have changed. But even though, for the sake of argument, it has been provided in this agreement. Huh? My lord, we have not tendered any. There has been no fresh tender up till now because this writ petition was pending before your lordship. Yes, my lord, because because they have challenged the termination itself by virtue of this writ petition.
But there was no string up on the floating of fresh tender.
My lord, but then
Only
doctrine of
protection to the extent of not to liquidate my security.
yes, my lord.
If
Yes,
they
my
have not done so, they have not done so, my
No,
lord.
my lord,
That's their own body.
I am not championing for that cause, but my lord, as the doctrine of lispendence says, my lord, because unnecessarily creating, my lord, third-party interest in case of a particular tender, my lord, when security deposit has not been given to them or has been not forfeited by him. So the chapter is not closed. So be that as it may, my lord, I just because since it had fallen from your lordship. So now, my lord, will kindly see. Now, my lord, I'll come, my lord. Now, my lord, again coming to page 92, 25, clause 25. Now, my lord, here, my lord, is the alternative remedy of appeal, which they could have gone, which they have not availed till date, my lord.
Yes.
Now, my lord, we'll kindly come to the next page at page 93. That is the exit clause.
28.
Clause 28. Now, my lord, very specifically, my lord, has been mentioned by the contractor. If it is not feasible for the contractor to continue the contract due to any reason, the contractor may terminate the contract by giving 30 days notice to the railway administration after completion of 6 months of the contract period. The complete security deposit will be refunded in such cases. This provision shall not be applicable on contracts of less than 6 months duration. So, my lord, he was given the contract, if my lord kindly recapitulates, on 26th of December 2022. And he himself, on his own volition, said that he will not load the wagons. That is his, my lord, notice which I have, page 120, from 26/5/2023. That was not 6 months, my lord. Five months. Now, my lord, 30 days. Then, my lord, I again come back to page 93. Then 28.1.1. In case contractor surrenders his contract before completion of 6 months or complete duration of the contract, whichever is less, his security deposit shall be forfeited. If the contractor does not give the due notice as per 28.1 above or fails to operate the contract during the notice period, then also the security deposit will be forfeited. So, my lord, in my respectful submission, one notice was also given, my lord. He should have waited, my lord, where we in unequivocal terms told him, please wait, we are looking into the matter and we will resolve the issue. But please don't, because then you will be inviting this particular clause. Now, my lord, then, my lord, by railway administration, that 28.2 my lord. Railway administration shall have the right to terminate the contract agreement for any reason whatsoever after serving 30 days notice to the leaseholder. Now, my lord, here when this comes, my lord, when 21 or 28.1 and 28.1.1 do not come into operation. Here, if we are going to, my lord, because this is at his behest, the behest of the contractor. So when contractor has to exercise his power, he has to exercise the power under 28.1. And if he doesn't, my lord, then 28.1.1 will follow, which we in page 122A had specifically stated, my lord, in the last paragraph. Now, my lord, then we say, my lord. And my lord, 28.3, my lord, will kindly see. We have also given us a safety valve that it is when we have to terminate for any reason, understand where we are bound to show reasons. The concept of hearing comes, my lord, if we give a notice under 28.2 or my lord 28.3, that is, we are, however, notwithstanding anything contained in paragraph 28.2 above, railways shall always reserve the right to terminate the contract as a punitive measure without any notice and at any time in the case of serious violation of agreement by the contractor. Now, so my lord, here we are not on that point that he has violated the contract. Therefore, we have terminated. He has invited such termination first because of his letter, which he said, you please give me back the money. I am not going to loan. We answered it that we are looking into the matter. Please do not go on with the contract. Don't unilaterally terminate it and invite 28.1. He did it at his own risk and peril. Now he is coming to this honorable court saying that I am going to give a go-by to 28.1 and 28 to 28.1 and 28.11, which is a part of the agreement which was signed by me without any coercion and with full knowledge and understanding. Now, my lord, here public money is involved, my lord. Will kindly appreciate. Here, my lord, we are Indian Railways. Indian Railway runs for public welfare our train every day. And we run our trains at a subsidized rate. And for the benefit of running it at a better rate and maintaining it, my lord, we provide all these ancillary commercialization of railways, such as providing advertisement and commutation, and using it for parcel vans is the biggest earner of revenue for us. Now, my lord, we in unequivocal terms, as far as our tender is concerned, when we floated, we said you have to use the rakes on day-to-day basis on payment of advance money. And if you don't pay advance money, you will be liable to pay 0.5. Now, you did not say that you should have taken into consideration whether the goods which are being commuted by you or being transported by you were of a nature, and railways may run in delay for 2 hours, 4 hours, 5 hours. My lord, we travel by railways, my lord. I book a ticket, my lord, of one particular railway, my lord. When I cancel it and I get back, they deduct money from me. Now, my lord, I will come to court that they should give me a hearing. They will, my lord, this cannot be, my lord. These are certain benefits which are given to the government being a welfare state, which has other larger things, responsibilities.
You continue on the next day.
My lord, I shall.
They're eating into hearing time.
My lord, I shall. My lord, then I will conclude.
I have a right of reply, my lord, so far as my learned friend has taken this.
My lord, only on point of law.
No, so far as the factual aspects are also concerned, probably my learned friend has not taken your lordship to the correct state of affairs.
In that case, my lord, then there will be no.
Do you have any other submission to make?
So far as the factual aspects is concerned, my lord, my learned friend has said that I have relied upon.
Let him complete.
I have not relied upon any old policy. All my
lord, it was annexed. It was annexed, my lord. Therefore,
because lordship, it has been annexed, but I have not relied. I have relied upon the latest circulars.
My lord, I'm not on that. My lord, I have also not relied.
I have also accepted that I have discontinued when I have.
Come back some other date. No further submission to make today.
Probably lordship 3:30. I can give a reply right now, but
my lord, I have not concluded. না না আমি শেষ কেন আমি তো আমার
order may be extended, my lord.
I was inviting that actually. When I asked him no submission to
No,
make,
I was no.
My lord will be pleased to keep it this side of the vacation.
Not possible.
We are unable to.
Have a week to go. It's not harming the railways in any manner.
Well, it is harming, my lord, because that amount we are, because when we are, my lord, fresh and
without that amount.
No, my lord, it is not that. What happens is, my lord,
it is a very paltry amount, my lord, 7 lakh rupees.
It is not a fault. And my lord, it is not about that amount. No, my lord, I am not about that amount. My lord, it is of running of my parcel vans. What is happening is now we
stay on that.
Yes. No, my lord, we are not getting, because what happens when a person comes he fares in a tender, he says that I'm going to give this amount. Now that is the best amount. Now, so he is under an obligation to pay that amount every day, which we had a secured amount. But now, since this person is not paying, we have to wait for day-to-day customers.
Now, my lord,
Someday we can.
No.
Not
My
necessarily.
lord, lordship, kindly
lord,
appreciate
be that
from
as it
their
may.
submission.
Your rates are free for fresh
My lord,
offers.
we are there, but below, there
Problems
is a
were so genuine in nature.
Prayer of the petitioner. and the
Yes.
petitioner.
No, my lord, they cannot, because that they are stopped under contract by sponsors.
My lord, may I only say one thing? The problems were so genuine in nature. The railways has found it wise that not to float any flesh tender, because whoever will come, he will also face the same problem. That is the reason railway has not given it to anyone.
My lord, we are railways.
This
My
is
lord,
the practical reality.
no, my lord, no practical. We are railways. We believe in lispendence. We don't want unnecessary.
And they are unable to earn money because of their own lack of infrastructure.
Question of dispendence in this matter. Anyway, and let the matter appear under the same heading on 24th June.
Lordship, interim order will make.
Paragraph, the interim order granted earlier is extended till 31st July or until further orders, comma, whichever is earlier.
Great. I'm grateful, my lord.
31st July.
Well, I already handed over the judgments today.
Yes, my lord.
Please consider them and come.
Yes, my lord, I shall come back. It would have been given to me.
24th June,
My lord's leave.
24th June.
One zero three one.
Lord, I appear on behalf.
Lordship, I beg to appear on behalf of the respondent authorities, Lordship. Lordship, in this matter, what happened? Lordship says, actually, I am newly appointed in this matter. Lordship, Lordship, that is the point, Lordship, that there is an observation by your Lordship on 28th November 2023 that affidavit in opposition has not been used by the respondent. But Lordship, so far the instruction given to me, Lordship, there is an affidavit in opposition in my brief, Lordship, that is handed over to my client. That is affirmed.
Affidavit in opposition there, my lord. Affidavit in reply also filed, my lord. Pleadings are complete.
তাহলে ওটা কি ভুল রেকর্ড ছিল নাকি? So that is wrongly recorded as
Dismissed in between, isn't it? Then restored.
dismissed ছিল।
The main application was, my lord, dismissed and then restored.
Let me
ক্যানটা
find out.
ক্যানটা
Can it?
ওটা ডিসপুট হয়ে গেছে তো।
No. Main can dismiss it. Can was for restoration.
Lordship, in that, may I humbly request Lordship that may kindly fix a date for hearing, Lordship, because even affidavit in reply, I don't have the copy, Lordship. Actually, it's a long old matter, Lordship. The client provided me with the.
No, that is on record at all.
That is, if Lordship, the opposition copy is not there, Lordship may kindly allow us to affirm it afresh,
No, opposition is there.
Lordship.
So there should be a reply also, my lord.
I'll just find out. It's a very old matter, actually.
Yes,
Yes,
Lordship,
my lord.
2010 matter, Lordship.
A reply which has been affirmed on 9th day of April 2013, my lord. Yes, my lord. 9th day of 2013 by one person, Gautam Chakraborty, my lord.
দেখুন তো এটার মধ্যে রিপ্লাই আছে কিনা
দিদি
অপোজিশনটা আছে ওটা এফিডেভিট ইন রিপ্লাই আছে কিনা চাইছেন রিপ্লাইটা
reply.
Affidavit in reply টা আছে কিনা ফাইলে?
এরকম লেখা থাকবে পেছনে, মানে এরকম লেখা থাকবে পেছনে।
It's not there in the file. The reply is not there. The opposition is there.
Lordship, even I also don't have the copy of reply, Lordship. No, I don't have, Lordship.
It's also a change brief for me also, my lord.
We reaffirm and file.
We'll reaffirm, my lord, but I have a copy of the reply, my lord. So I can basically reconstruct on the basis of the reply, which,
There at
yeah,
all.
we'll get it reaffirmed and we'll file it, my lord. I'll also serve my learned friend also.
Lordship, may humbly request Lordship to may kindly modify the order dated Lordship that where it is recorded that affidavit in opposition is not filed, Lordship. That order may,
I'll record. It's on
Lordship may kindly.
reply.
Acha.
It's there.
Hmm.
But it's very old matter, so
Yeah, very old
it
matter.
needs to be discussed.
9th April, দেখুন তো 9th April,
না 9th মে আছে।
এটা কিন্তু 9th April দেখাচ্ছে।
গৌতম চক্রবর্তী,
নাও না রেকর্ডটা নাও না
একবার একটু দেখতে পারি?
দিন না একবার দিন আমরা দেখে বলে দিচ্ছি।
এখানে
হ্যাঁ,
কিন্তু
এপ্রিল
affidavit-
এপ্রিল এপ্রিল এপ্রিল।
এই সময় দেখাচ্ছে রিপ্লাই।
হ্যাঁ,
এটাই।
I'll record that they're on record.
No.
Affidavit in opposition. Affidavit in opposition filed by the respondents
Copy আছে।
and affidavit in reply filed by the petitioner are on record. Paragraph, the matter is ready for hearing. Paragraph, let the matter appear under the same heading. Hearing me ask. 28th June.
Lordship.
My lord, just one humble indulgence, my lord, because in this matter, what has happened earlier, someone has appeared and thereafter on the next day, the concerned advocate doesn't appear because of lack of instructions. So I presume my learned friend at this point of time will not ditch us on the next date.
No,
And
no,
he'll be left
we are appointed with the proper instruction, Lordship, that will continue because that is as there is a order, Lordship, that affidavit in opposition is not filed by the. That's why, Lordship, Lordship, that liberty we need.
An old matter, we also want to be.
Lordship, we also want to get it hard by the Lordship 28.
So please come prepared. I'll deal with it.
Lordship, I am
Next.
grateful.
One zero three two.
The matter hasn't become infructuous. The earlier matter.
কি বলছে?
Yes.
আপনাকে কি বলছেন? কি বলছেন?
Matter hasn't become
1032.
infructuous.
No,
The
no, ma'am.
earlier matter.
No, no, man.
2010. That's what.
Actually, I'll be very candid, my lord. What we have claimed over here, my lord, in terms of a circular, we were supposed to get benefit of 30% discounts on the reverse cycle. Now, we have already availed the benefits. We have overpaid the railway. So what we are saying essentially is in terms of that circular, we are entitled to get this particular amount. So if I am able to demonstrate before the court that I was entitled to the benefits under the circular, then I have a claim. If I am not able to demonstrate, my claim goes.
Yes, the next matter, 1032. Petitioner,
I appear on the petitioner, my lord.
you wanted to use an exception?
Yes, we have filing an exception, my lord.
And take inspection of the goods. Have you done?
Yes, we have taken. My lord will kindly.
It has been served.
It has been served prior to the. Lord, there's some stark contradiction on the report and the exception, my lord. Because what we have found, we have engaged a private agency. Lordship will kindly come to paragraph 8 of my exception.
Actually, paragraph 5 onwards, my lord. We had engaged an agency named SGS Private India Private Limited. They had visited the site, taken inspection, and lordship there in paragraphs 12 onwards, I have pleaded that there's some contradiction insofar as the report is concerned and my exception. Because the goods I am saying, the chemical value of the goods has reduced. Paragraph 9, your lordship will see.
Passage of time.
With passage of time, the goods were not properly protected. The quantity has reduced. And I have been continually renewing the bank guarantee. It is still on as on today, as I submit before your lordship. So there is some contradiction, my lord. I have prayed in my exception. I have prayed an independent person be appointed to take inspection, because your lordship will not go by my exception, neither by their report. I have annexed the photographs, page 8 onwards.
Accepting your exception?
Yes. Only thing, lordship, kindly sees. May I submit? The initial goods were submitted at page 38. Your lordship will see my exception to the report. 38 and 38A, the typed copy, my lord. Your lordship will kindly come to 38A, serial number 6, quantity and quality of the mineral / ore to be transported. Let the quantity is there, 1000 metric ton. The quality is plus 65 Fe. Fe is the quantity of iron contained in those ores. So that has reduced significantly. Your lordship will see as the report of the new agency who has taken the inspection at page 36. Yes. At page 37, your lordship will come. Page 37, my lord, there's the chart. Number of stocks, stack 1, stack 2, and stack 3. They have disclosed that it is kept in somewhere, Barbil, Keonjhar, in Orissa, in 3 stacks. Now, lordship will find the Fe percentage adjacent to that, 60%, 0.88, 48%, 0.89, and 62%, 0.41. But the quantity has reduced, lordship, and that the Fe percentage is the main thing in iron ore, because it signifies how much ferrous is contained in the mineral. Yes. The quantity has also reduced. In the first page, page 36, your lordship will find the total quantity as assessed in these 3 stacks.
Here it indicates there's only 1 stack in your earlier document, 38A. 3 stacks are not demonstrated there.
It has been annexed subsequently also. Page 38 onwards. Page 38, 39, 39A, I've annexed. At the time of when the goods were sent, the form 1 that I was supposed to submit is a little illegible. Hence, I've given the typed copies. Now, what has happened, your lordship, page 36 and 37. 37 speaks about the quality has been compromised because of the Fe percentage coming down. And page 36, your lordship will see the total quantity has been assessed at 1156.54. Whereas in my affidavit, page 5, para 14, I have averred that the quantity was originally 2054 metric ton. It has been reduced to 1156. But possibly it has come down because it has not been protected. It has fallen into the ditches because it was apparently stacked at the side of the railway tracks. So due to weather conditions or whatever, not being protected has compromised the quality, and the quantity is also been misappropriated or been stolen. But we exactly do not know, but we could decipher as per the report of this agency. Yes. Now, your lordship, I have prayed in my paragraph 11 and 12 that let an independent person be appointed to take inspection and commission. Because otherwise, my prayer in the can too, my lord, is let the bank guarantee not been renewed in the view of my goods being not been properly protected and been misappropriated. Your lordship will have to come to the conclusion that the goods are properly kept or not. That is the difficulty, my lord. Because I have been maintaining this bank guarantee since 1st October 2010, when it was initially passed by Honorable Justice Indira Banerjee's order. And nowadays, bank guarantee renewal, a lot of commission and 100% margin is to be given, my lord. It's a tedious task. Well, it is my submission that the goods are misappropriated or lost or quality is compromised. But I am compromising there also. I am compromising by renewing the bank guarantee from 2010 onwards till 2014. As per instruction, the bank guarantee is still live.
Yes, let us hear the railways.
May I submit? My lord, the subject is, my lord, iron ore.
This inspection was done in your presence?
Independent, they have indicated. They have indicated that independently they have conducted. First, my lord, what is the material? The material is iron ore. My lord, a finished goods, my lord, like TMT rod, if it is brought in open air, since 2007 to 2024, automatically, my lord, it will be depreciated.
Was the duty, the responsibility of the authority to preserve it?
No, responsibility of the authority. We have allotted a particular area that you can stack it in open air. That was their knowledge within the agreement when the agreement was, my lord, signed between the parties.
Authority has no responsibility.
We have allotted the area. We have allotted the area and the space.
Further,
Nothing. Because, my lord, they are to lift it. They are to lift it. We are enjoying the rent only. Now, since 2007, if your lordship kindly thinks this way, they are occupying the same without having any proper renewal of the agreement. Because it says that firstly, they have agreement, the agreement between the parties were done January 19, 2007. And we have allotted a particular space in the railway area that yes, there are space, open air, as is where is basis, you can stack there. Thereafter, the charges were not allowed. We have hold it. For such reason, the court was kind enough in the year 2010 that yes, we have to provide the bank guarantee. Bank guarantee they have given.
It is permitted to shift the material upon furnishing.
They have not done it. They have not done it. Now the responsibility goes upon whom? Thirdly, my lord, the ferrous automatically, my lord, within the air, my lord, I do not, my lord, want to say the chemical compositions, ferrosulfuric oxide, ferrous oxide, there are other components. Automatically, the value of the net content of the ferrous will be depreciated. Automatic. Because unless and until, my lord, manganese and chromium are added with the ferrous, it cannot be protected.
So the clearance was upon the petitioners.
Exactly. But we have allowed the space only for which we are getting the levy from them, revenue. And the revenue part is protected. Not only that, my lord, now the issue, my lord, if your lordship kindly sees this way, 2007 to 2024, in the agreement, there is a clause of arbitration. They ought to have gone there. Because it's not.
That the court can take up, that's not an issue. The
Now,
court can take up the matter despite there being a clause for arbitration. So
yes.
that's all right.
Now, my lord, what we will do? because we do not need the iron ore. We have allotted the only space. That is their property. Till now, they are admitting that that is there. That has not been stolen. The value or the content of the ferrous that has been reduced, as it was in open air last 17 years. Since 2007 to 2024.
And it is at the Barbil siding.
Same. Location is not disputed. Nothing has been disputed. What I am on, Millard, subject to Lordship's kind sanction, let the entire writ petition be heard, finally. Because that is to be, that is required.
In fact,
and it has been renewed by them for 1 year automatically.
Lord, may I submit one thing? I have filed another can, which is a prior can. There I have prayed for the railway authorities be directed to sell and dispose of the materials. That is still pending.
Why should I take the
I had
responsibility?
prayed and submit the sale proceeds.
No. Let them sell it out. Let them sell it out. Their property.
So, isn't it?
But I was at liberty, but the scan was still pending.
Okay.
Unless the scan was heard out and I
finally.
have been allowed to sell.
It is your property. You have furnished a bank guarantee. The court had directed to release your property. So there was no bar on your part.
Millard,
You could have done that long back.
yes, Millard, in that regard,
Of the
Millard, in that regard, why I had filed can 2
Can 2
comes into question because
now, Millard,
I had
petition be heard.
I had to file can 2 after
No,
several
another
requests
can is being
that
filed.
you please let me know where are my goods. Despite several letters and communication, then only I had to file can 2 because they were not able to answer my question as to where the actual goods are.
Ultimately, what they have found?
The goods are at the same place.
Millard, but the quality and quantity
Quality
is
and
not as it was.
I agreement that the railways were responsible for preserving it.
Millard, I understand the question falling from your lordship, but Millard, Millard,
Railway has given you the
space.
I understand the question falling from your lordship.
Upon furnishing bank guarantee, you were permitted to shift the goods from there.
Exactly.
Right. So there was no bar to dispose it of, which you have not done till date.
And lastly, Millard, as it is a perishable goods, for such reason, court has directed.
Here of the writ petition itself.
Yes, Millard, please.
Okay, my lord, if I may submit something. My lord, the first order which was passed by this honorable court is in the my can 2, my lord, page 60, my lord. I was allowed to sift the material on furnishing the bank guarantee. I have furnished the bank guarantee. After furnishing the bank guarantee, I kept on writing them that please let us know where my material is lying. My lord, here the question arises. They say that they have given me a site where I have to keep those material. I have kept it there, my lord. But ultimately, when it came to my knowledge and transpired, my lord, that the material is not at that site, my lord. That is why, my lord, we have written several letters, which is part of can 2, my lord.
That part is over now, isn't it?
My lord, may I come? May I, my lord? May I, one second. After I filed this can 2, my lord, this order has come up that somebody will go and check whether the material, where the material is lying. I've independently appointed, after they filed a report, appointed an agency which has gone there. The material today, my lord, is not at that site. Number one, my lord.
This is unfortunate.
Let me complete.
Unfortunate.
complete.
একই মামলা দুজন কাউন্সিল করবেন কি করে? যে কোনো একজন বলবেন।
Please do not repeat. He has said the same.
Exactly.
No, I'm two things, my lord. One is
তাহলে তো আমার
my
পাশের
learned
জুনিয়র
friend
আবার
has
আমার
said
হয়ে বলবে।
that it is not there, my lord, because no material is allowed to be kept at the side of the railway line where there is a ditch. The entire material has fallen into the ditch.
It was within your knowledge.
No, my lord.
Because
No,
the
it was
location
not.
has not shifted.
No, material has shifted. This is my allegation, my lord. Specific allegation, my lord. Material has been shifted from the place where I have stacked it.
You were given the liberty to shift your material right from
No,
the
my
first
lord.
order of the court.
They have shifted it, my lord. We have not shifted it.
Why haven't you shifted? That is my question.
Because we were not getting the material where we have stacked it.
Yes.
The material was not there.
Let the repetition be heard of.
Yes.
This is,
My lord, kindly,
redundant now. I'll fix a date. Let the repetition.
My lord.
be heard.
my lord, at least,
Sir, excuse-
Yes, yes,
my lord,
complete.
at least relieve us from renewing the bank entry, because one thing, my lord, because the quantity and quality has reduced like anything.
That will
I am
be-
suffering double jeopardy, my lord,
that will
because
be, because what is the fault of the railways?
It's a final relief. What he is praying.
Do not give this running commentary, please.
my only thing is, my lord, the fault of the railway, if I can answer your lordship's answer, is that they have never responded to my any request. At least identify where my material is there. They have not, my lord. I'll show it from my can, my lord.
If you're
My lord, my lord.
exception, the WPA along with can bole bole, na? Exception used by the petitioners to the report filed to the report in the form of affidavit filed by the respondents is taken on record. Paragraph. The writ petition is ready for hearing. Paragraph. Let the matter appear under the same heading on 2nd July.
My lord. Grateful. এখন আর হচ্ছে না
Other council said,
1033.
This is my application.
Affidavits are issued.
Affidavit has been, it has been, affidavit has been exchanged between the, between us, and it has also been submitted before your lordship. Now, my lord, it's a case, my lord, pursuant to the invitation as well and also the notification issued by the South Bengal State Transport Corporation for appointment of the selling agent in a particular route. The petitioner applied for the said routes, my lord.
For appointment of?
For appointment of the selling agent, the ticket selling agent. The petitioner has applied for the said routes. The petitioner being a successful bidder, petitioner was appointed as a selling agent in the particular routes. My lord, that is annexure P2, my lord, page 30. It starts from the page 30, 31, 32, 33, 33. There the petitioner has deposited the necessary fees as regulated by the respondent State Transport Corporation, South Bengal State Transport Corporation. Now, my lord, all on a sudden, they issued a letter and thereby cancel the petitioner appointment as a selling agent in that in those routes. The petitioner has made a representation to the authorities concerned, inter alia asking to the respondent authority that your appointment that while rejecting or while cancelling the appointments of the petitioner in the different routes, no reason was shown by the respondent Transport Corporation. Now, my lord, in the meantime, the matter was heard and this honorable court was pleased to direct to file the oppositions. And my lord, the versions of the Transport Corporation while opposing my petition is that the first point was that the partnership firm, the Vishwakama, it is an unregistered firm. And second one is that this is the appointment of the selling agent. It is not the viable as such. As a part of the policy decision, they cancel my appointments. Now, my lord, in replying the oppositions, my lord, I categorically state that the section, my lord, kindly have a glance at
page 5, paragraph 6.
Of the writ petition.
Yes, my reply.
Oh, reply.
Yes.
Opposition has been filed by only
By
one
that,
of the
by the South Bengal State Transport Corporations.
not by the state.
With regard,
Not necessarily.
they are the answering respondents.
Yes.
No, with regard to the maintainable, whether the writ petition, they raise a question, whether the writ petition is maintainable or not. I answer my answer in my reply in paragraph 6. If your lordship allow me, I read the portions.
Yes.
With regard to the paragraph such and such of the said affidavit in opposition, defendant does not admit anything save and except those appears from record, and it is denied that writ petition is not maintainable. And as per section 59 of the Indian Partnership Acts, because of the validity of the document, which is an unregistered instrument, consequence of which it lays down a bar for any claim arising therein for enforcement of any right forming the contract, the applicability of the bar for non-registration, and in that constate the expression other proceeding in section 69 subsection 3 of the said act was interpreted to mean in the proceedings of any kind which can properly said to be enforcement of any right arising from contract except those expressly mentioned as exception in subsection 3 and 4 of section 69 of the Partnership Act. The question of maintainability and the ban of proceedings for non-registration is not applicable to the instant writ proceedings, as the condition precedents for the operation of ban, as mentioned in section 59 and 69, is only applicable for the launching of a suit in a court of law, where any claim by unregistered firm or by a person claiming to be a partner of an unregistered firm, either to a claim for set up in the said suit or any other proceeding intrinsically connected with the said suit. So this is my answer with regard to the applicability. Now, my lord, the second thing is they said, second point they raised while objecting my petition, that this is a policy decision. Now, my lord, while appointing me as a selling agent, there is no single whisper that it is a policy decision. And the third one is that whatever be the nature of appointment, a reasonable opportunity must be given to the petitioner. But without assigning any reasons, arbitrary decision cannot be taken by the respondent transport corporations. This is my submission.
The writ petition has become infructuous by virtue of the fact that the system of booking of paper tickets, that has been discontinued by the corporation from 2015 onwards. Now, he is asking for right to continuation of a booking agent of paper tickets. It cannot be given. So today, your lordship cannot pass a mandamus directing that continue him as a booking agent for paper tickets.
What is the prayer?
He wants to continue as a agent to give effect to the memo.
I challenge the
completely online. Give further appointment to the petitioner as selling agent under the South Bengal State Transport Corporation. This was for paper tickets.
Several memos.
Sir, their appointment in the several routes, and by the several
Each memo for each route.
Each route. It was started.
Where is the appointment?
There was no appointment as such. He is relying upon pages 30 and 31, which says below that the operation shall start with immediate effect for a period of 3 months, purely on trial basis, which will be reviewed accordingly. So it was a trial basis run. Kindly come to page 30, my lord. This is the first order. The route is page 30, annexure P2. Your lordship has seen, my lord. Now kindly come to the last paragraph, my lord. After 11. After 11, the operation shall start with immediate effect for a period of 3 months, purely on trial basis, which will be reviewed accordingly. The selling agent shall execute a contract with the corporation before the date of commencement of the order. No contract was executed. It was a trial run for 3 months, after which it was not continued, my lord, because paper ticket system has been abolished. Now it's entirely, my lord, e-ticketing through, my lord, a principal booking agent who is engaged. So today, he cannot get an order of appointment as a paper ticket selling agent. This is the first thing. He cannot continue.
But
And
the
secondly,
fact remains, I have deposited the security money as well as the collections of the regular, and and those amount are the still lying lying with the corporations, my lord.
The documents of your depositing security money?
page 31, Lord, it says
31?
that you have to deposit a sum of
34.
25,000. It does,
25,000.
yes, it does not say it shall be non-refundable. I don't find it.
34, my lord. 34, 35. My lord, if it is not possible now at the present juncture, my humble prayer, my lord, kindly give a direction to the respondent state transport corporations to release the amount what I have paid as a security deposit with them, my lord.
That can be done because it doesn't say
But
non-refundable.
that has to be
But
calculated.
only one
That
thing,
has
he
to be
has to pay a
calculated, my lord.
monthly sum of
Give a
rupees
direction.
6,000. We shall check up whether or not the amount has been paid or not, and we
That
shall
has-
adjust.
And and Mansa as well as to give me an opportunity of hearing. Because the necessary papers, documents is required to be produced. Their calculation may not be matched with me. In that case, again, the dispute will arise.
Let this be disposed of. I no need
Yes,
of
Lord.
keeping it pending.
No, no.
I'll record your submission.
That not, we are now discontinued. We have not discontinued
Let
the
me assess the amount of refundable to him upon hearing him.
file.
Upon hearing.
No, two contentions. First, it is trial run for 3 months. After that, it was not renewed. And second submission is that it has become infructuous because no more the system of paper booking is there in corporation.
But though it is on the trial run basis, but there is a mention in the appointment letter when they will execute, when they will.
Where is your appointment letter?
My lord, kindly see the appointment.
Page 30, you call it an appointment letter?
Kindly see the appointment letter. It starts from page 31. Page 30. Agreement. Page 30.
30.
Page 30, annexure P2. This is the appointment letter for a particular route is the Kalna to Balurghat second.
Vishwakarma Travels is
And the last sentence is a very important. The selling agent shall execute a contract with the corporation before the date of commencement of the order.
Which was never executed. That is not my case. The contract was never entered into.
Was such a contract executed between you?
Yes, I have executed the contract also with them.
Yes, where is the contract?
Page 31 is to be read with page 30 because page 30 is the order and 31 is the continuation just after 1 month. So 3 months has not expired. This within the period of 3 months.
Prior to the 3 months, my lord.
Yes.
They never made any positive intention to execute a contract. But without any latches, without showing me any latches on my part, they whimsically cancelled my appointment.
No right has fructified in his favor, and secondly, now he cannot get an order because
there must be a reason, my lord.
The system is abolished.
Because
When was it cancelled? After 3 months?
The cancellation was made on within 1 month.
Where is the letter included?
Annexure P4
At page?
at page 40. It starts from page 40, 41, 42, and 43. The different month. The first one is on the 30th of October. Second one was the 22nd.
Immediately after issuance of
Just 1 month.
yes, after
Yes.
the order was not of 9th of September. First one is not
4th of September.
4th of September.
This is 30th October.
And cancellation is 30th October. So September after 2 months, he
2 months.
functioned. After that, it was discontinued.
It did
And the
not-
second one was second one is this is the route from the Durgapur to Balurghat. It was cancelled on 22nd day of December 2014. And the last one is on page 43. It was cancelled on 24th day of, it was from Kalna to Balurghat.
Yes, this is after more than 3 months.
More than 3 months.
So that's fine. It was a trial run for 3 months.
Trial month for 3 months. But
But no,
my now at the page, now they are saying that this is their policy decision. It is not possible for them.
held that you were to be given an opportunity of hearing.
Yeah.
Now it has become redundant.
No, I am not asking for the opportunity of hearing, for the appointment. Now at the present juncture, my lord, it is an admitted position. They change the policy. I am in a no way appointment as a selling agent because I cannot challenge the policy decisions of the unless or until if there is any arbitrariness. Now, my lord, my only prayer before this,
Assessment for refund.
to assessment the amount what I have paid as a security deposit or other charges, it was lying with the corporation. My lord, with that extent, my lord, kindly give me an opportunity of hearing so that
Yes, I'll declare. Third learned counsels for the parties. The petitioner was the petitioners were appointed as ticket selling agents by the South Bengal State Transport Corporation. Comma being the second and third respondents herein. By an order passed on by several in different routes by several orders dated 4th September 2014, 13th May 2014, 9th October 2014, and এটা মাঝে ঢোকান 25th April 2014 সিরিয়াল ইউজ করবেন 25th April 2014 মেয়ের আগে ঢোকান মেয়ের আগে ঢোকান The service of the petitioner was cancelled by the authority without granting any opportunity of hearing to the petitioners. The petitioners are aggrieved by the said decision of the authority and submit that an opportunity of hearing ought to have been granted to them prior to termination of the contract, comma, more so, comma, since the petitioners have deposited security deposit before the authority in this regard. Paragraph. Learned counsel for the second and third respondents submits that the concept of ticket selling agent, ticket selling by agents has been given a go by a policy decision taken by the authority, and the entire ticket selling is done and e-tickets are issued to the passengers. Learned Counsel for the respondents submits that the writ petition has become redundant and redundant in view of the policy decision of the respondents, and there is no scope for reappointment of the petitioners as ticket selling agents. Paragraph in reply, Learned Counsel for the petitioners submits that the authority be directed to refund the security deposit and other charges deposited by the petitioners with the authority at the time of inception of the contract. Paragraph. It is not in dispute that the operation was for a period of 3 months purely on trial basis, and no contract was executed by the petitioners with the corporation as required in the orders of the authority. Since there is no provision for selling tickets, for ticket selling by agents at present, the prayers in the writ petition have become redundant. Paragraph, however, the second and third respondents are directed to consider refund of the security deposit made by the petitioners with the authority within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, in accordance with law. Disposed.
I'm grateful. Deep level.